anyone being related to them by blood or marriage or knowing them from any business or social relationship. I'll say their names, assuming we have none. Then I will just look to you to call your first witness.
Thank you, Your Honor. And in addition, we could do Mr. Absher's Thank you. Yes.
Okay, then Mr. Absher, if you will come forward and be sworn, sir.
Do you solemnly swear or affirm that the testimony you give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
All right, Mr. Absher, you, of course, have been seated and listening carefully to your trial, and you have been present for the state's case in chief. You have now seen all the testimony and seen all the evidence that the state is intending to prove in this case. Do you understand that it is the state's burden to prove these charges against you beyond a reasonable doubt?
Yes, ma'am.
As such, do you understand that you do not have to prove or disprove anything? Do you understand that?
Yes, ma'am.
And so that means you also do not have to testify in this case. You have the absolute right to remain silent. Do you understand that?
Yes, ma'am.
Of course, you also have the right to testify if you choose to do so. Do you understand that?
Yes, ma'am.
This decision about whether or not you should testify or not testify is yours and yours alone to make. Do you understand?
Yes, ma'am.
You have a skilled attorney whose advice you should certainly listen to and consider, but at the end of the day, the decision about whether or not you wish to testify is only to be made by one person, and that is you, Chad Absher. Do you understand that?
Yes, ma'am.
Now, if you choose to testify, or rather, let me begin. If you choose not to testify, if you wish to invoke your Fifth Amendment right to remain silent, which you have the right to do, I will advise this jury, as I already have, and I will advise them again, that in every criminal proceeding, a defendant has the absolute right to remain silent, and at no time is this jury permitted to draw any inference of guilt from your exercising of your right to remain silent. Do you understand that?
Yes, ma'am.
I will also tell them that the fact or that you chose not to take the witness stand should not influence their verdict in any manner whatsoever. Do you understand that?
Yes, ma'am.
On the other hand, if you choose to testify, then you will be treated like any other witness. You will come over here to sit in this witness stand. You will be placed under oath to tell the truth. And you will be examined by your attorney and cross-examined by the state attorney. Do you understand that?
Yes, ma'am.
And, like any other witness, if you have any convictions for felonies or crimes of dishonesty, that fact will then be made known to the jury. Do you understand that?
I got felonies.
I understand. I'm going to go through those in just a minute. But do you understand that if you choose to testify, then the jury will learn that fact, versus if you choose not to testify, they would never know that fact. Do you understand that?
Yes, ma'am.
Okay. And so, state how many either felony convictions or convictions for crimes of dishonesty, how many of those certified judgments and sentences do you have on hand?
I have one certified judgment and sentence that has 2 felony convictions, Your Honor.
And Ms. Edwards and Mr. Absher, have you had an opportunity to see that certified judgment and sentence containing those 2 felonies?
I'm not yet, Your Honor.
All right, can you provide that to the defense?
I had provided that in discovery, Your Honor.
You did provide it. I just.
But I have my
reshown it right now.
certification to show, but that was provided in discovery.
Okay, very good.
Admittedly, it was. I just
All
have
right,
not.
let's just let him see it again. But this is one document that has 2 felony convictions on it.
Yes.
And in fact, it's one of them is what's part of count 3, Your Honor.
I understand. All right, there it is. Mr. Absher, if you want to look at that. All right, so and let me explain how that process would work. Just as with any other witness whose credibility can be impeached with these convictions, it would just be the fact that the conviction exists, not the nature and details of the conviction. In other words, if you agree and stipulate that you have 2 felony convictions, as that document shows, that would be the extent of the questions asked. It would be, Mr. Absher, have you ever been convicted of a felony or a crime involving dishonesty, and if your answer is a truthful yes, then it can be how many times, and if your answer is a truthful 2, that would be the end of the inquiry. Do you understand that? Now, if you are not truthful with those 2 answers, if you say you don't remember, or if you say 1, or if you say none, then the state would be allowed to introduce that document, the certified judgment and sentence, and that would then show the nature of the crimes with which you've been previously charged. Do you understand that process? Right, but I'm just making sure that you understand if you choose to testify and you testify differently than 2 felony convictions, then the state would be allowed to introduce that document as evidence. Do you understand that? Okay. And do you agree that you do have 2 prior felony convictions? Okay. Now, have you had sufficient time to consult with your attorney about whether or not you wish to testify? Has she answered all of your questions regarding that decision to your satisfaction? Do you need any other time to consider your decision? You do? Okay. Well, as you know, we're going to be calling 2 witnesses, or your attorney is going to be calling 2 witnesses on your behalf here. So that'll give you some additional time to think about it and to talk to her when we take another little recess. But then I'm going to ask you after that if you've had sufficient time. I know you all also discussed it. You got to think about it overnight last night. Is that correct? Okay. And I'll give you some additional time, but then I am going to be asking you what your decision is. Do you understand? Okay. All right. Then you can resume your seat, and we will get the jury out here and get started with the defense witnesses. All right, then. If there is nothing else, let us bring out the jury to continue trial. Ladies and gentlemen, you may resume your seats, and please be sure the notepads you're collecting are your notepads. As you may recall from yesterday afternoon, the state has now arrested its case. So at this time, I will turn to the defense to see if you have any witnesses you wish to call.
Yes, thank you, Your Honor. If we can first call David Finley Williams, please. Oh, Your Honor.
Yes. Let me also inquire, I failed to mention these 2 names during jury selection to see if any of you were related to these witnesses by blood or marriage or knew them through any business or social relationship. So let me tell you their names now. It's Mr. David Finley Williams and Mr. Reed Hart. Does anyone know those 2 individuals by blood or marriage or business or social relationship? If so, please raise your hand. All right, I see no hands raised for the record, so Ms. Edwards, you may call your first witness.
Thank you, Your Honor. If I may call David Finley Williams, please.
I'm sorry, he's in the restroom? Okay.
If I may call Reed Hart, then, Your Honor, please.
Oh, wait,
Oh, wait,
here we go. Okay. All right, Mr. Williams, if you'll come forward and be sworn.
Do you solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may proceed.
Good morning, Mr. Williams. How are you?
Good morning, I'm doing well, thank you.
Great. Can you please introduce yourself to the jury?
My name is Finley Williams.
And what did you do for a living?
I'm a criminal defense attorney.
Okay. And did you come to represent Ms. Lisa Rucker sometime in 2019?
Yes, ma'am.
Okay. And can you tell me what she was charged with when you came to represent her?
I believe it was retail theft and providing false information, I believe.
Okay. And do you know if she entered a plea to that case?
Not initially, no, ma'am.
Okay. And so did she eventually enter a plea?
Yes.
Okay. And can you tell me what her maximum exposure would have been on those charges?
I believe the original charge was a third-degree felony, so it would have been 5 years in the Florida State Prison. The 2 other charges were, I believe, first-degree misdemeanors. Each one would have been 12 months in the county jail.
Okay. And do you recall what she ultimately pled to?
I believe the state attorney's office dropped the felony charge and she pled to the misdemeanor charges and she received 12 months of probation.
Okay. Thank you very much. I have no more questions.
Thank you. Is there any cross?
Yes, Your Honor. Your Honor, may I proceed?
Yes.
Good morning, Mr. Williams.
Good morning.
You've been a criminal law attorney for over 10 years, is that correct?
That's correct.
And you're board certified in criminal law?
Yes, ma'am.
You've spent more than half of your career as an assistant state attorney in our office here in Jacksonville, is that correct?
That's right.
And the rest of your criminal law career you spent as a criminal defense attorney?
Yes, ma'am.
Now, the case that was mentioned just now, you said that Ms. Rucker did not initially enter a plea to her charges, is that correct?
That's correct.
She was sent to a felony pretrial intervention program, is that right?
Yes, ma'am.
And that was not done by Ms. French, is that correct?
That's correct.
That was not done by Mr. Atkinson.
No, it would have been the line attorney at the time.
That was not done by myself either, though.
Right.
When she did enter, or excuse me, the only reason that she was arrested on those charges was because Ms. French actually identified her as a suspect, is that correct?
I believe that's correct.
And when she was identified by Ms. French, she was arrested.
Yes.
She did not receive a notice to appear,
She did not, no.
and her charges were not dropped.
Not in that case, no, ma'am.
Now, based on your experience as a criminal law attorney, you believe the disposition given to her in that case was appropriate given the charge itself, her criminal history, and the facts of the case, right?
I do.
That disposition was in line with dispositions you see take place in this courtroom every day, is that right?
It was.
How many petty theft cases have you been involved with on either side, whether it was the state or defense?
A lot, hundreds.
Hundreds. And in those hundreds of petty theft cases that you dealt with, how many times have you seen someone receive the maximum penalty?
0.
You've never had any conversations with me after Lisa Rucker got arrested to get her any sort of deal or benefit, is that correct?
Correct.
You never had any sort of conversations with Mr. Atkinson after Ms. Rucker was arrested to get her any sort of deal or benefit, is that correct?
That's correct.
And you never had any sort of conversations with Ms. French after Ms. Rucker was arrested to get her any sort of deal or benefit, is that correct?
That's correct.
Thank you, Your Honor. No further questions.
Thank you. Is there any redirect?
No, Your Honor.
All right, may this witness be excused?
Yes.
All right, thank you, Mr. Williams. You're excused from free to go.
Thank you.
All right, you may call your next witness.
Thank you, Your Honor. If the defense may call Reed Hart.
All right, Mr. Hart, you'll come forward and be sworn.
Do you solemnly swear or affirm that the testimony you give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Good morning, Mr. Hart.
Good morning.
Can you please introduce yourself to the jury?
Yes, ma'am. Reid Hart, R-E-I-D-H-A-R-T.
Okay, and what do you do for a living?
Attorney.
Okay. And did you come to represent Lisa Danielle Rucker during 2017 and 2018?
Yes, ma'am.
Okay. And do you recall were there 3 cases during that time?
Okay, you
It was under 3 case numbers, it was essentially 2 cases.
Okay. So can you please tell the jury what she was originally charged with in those cases?
One of which was grand theft, and I think 2 counts of petty theft, and the other was uttering a forged bill.
And did she enter pleas to these charges?
Not as charged.
Okay, so were the charges amended to a lower charge?
Correct.
Can you tell me what those charges were amended to?
Both of them were amended to first degree misdemeanor petty thefts.
Okay, and did she receive any jail time or probation as a result of that?
The 1-day credit. And then unsupervised probation because it was a withhold of adjudication, so for it to be a legal sentence, there had to be 1 day of unsupervised probation.
Understood. Thank you very much. I have no more questions.
All right, is there any further?
Yes, ma'am. Good morning, sir.
Good morning.
You've been a criminal law attorney for 13 years, is that correct?
Yes, ma'am.
And you represented, as mentioned, Lisa Rucker on the grand theft charge in 2017.
Yes, ma'am.
You understand that the Florida legislature has since changed the law regarding grand theft, is that correct?
That is correct.
So if that crime was committed today, it actually would no longer be a third-degree felony for grand theft.
Correct. It would be exactly what she pled to.
And based on your experience as a criminal law attorney, the disposition given her on both of the cases mentioned was appropriate given the charge, the facts of the case, and her criminal history, right?
Correct. Correct.
The dispositions that she received were in line with dispositions that you see take place in this courthouse every day.
Under those facts, yes, ma'am.
And how many petty theft cases have you dealt with in your time?
Countless.
And in those countless number of cases, how many times have you seen someone receive the maximum sentence?
0.
You never had any conversations with me after Lisa Rucker was arrested to receive any sort of deal or benefit for her, did you?
Correct, no, ma'am.
You never had any conversations with Mr. Atkinson after she was arrested regarding any sort of deal or benefit.
Correct.
And you did not have any conversations with Ms. French after she was arrested regarding any sort of deal or benefit.
Correct. I did not have any conversations with anybody.
Thank you. Your Honor, I have nothing further.
Okay, thank you. Is there any redirect?
Yes, Your Honor.
Mr. Hart, in your 13 years of experience, have you had some clients that were state witnesses?
That actually testified on behalf of the state?
Yes.
Not that I can recall offhand.
Okay. Well, then I have no more questions. Thank you.
All right, may this witness be excused?
Yes, Your Honor.
All right, thank you, Mr. Hart. You're excused and free to go.
Thank you, Judge.
All right, ladies and gentlemen, I'm going to have to ask you to step back into the jury room for just a moment, so please leave your notepads behind, and we'll bring you out here in just a moment.
All rise.
All right, the jury's out of the courtroom. Let me just ask defense, do you anticipate any other witnesses that you wish to call separate and apart from Mr. Absher?
No, Your Honor.
Are there any documents or exhibits that you are planning to introduce, except for any perhaps through Mr. Absher?
No, Your Honor.
And so, I'll ask you, Mr. Absher, you're still under oath. Do you need additional time to make this decision about whether or not you wish to testify, or have you so decided?
You can run that 5-10 minutes.
Okay.
Please.
Satisfaction with regard to this matter about whether or not you should testify. And so, have you made your decision?
I'm right, I'm good. Yes, ma'am.
Okay, and what is your decision?
So, go ahead.
Okay, so you wish to testify?
Yes, ma'am.
Okay, sir. Has anyone threatened you or coerced you in any way in order to get you to make that decision?
No.
Has anyone promised you anything in order to get you to make that decision?
No.
Have you made that decision freely, willingly, and voluntarily? And, all right, then in just a few moments, we'll bring the jury out, and you will come forward to take the oath and testify on your behalf. Let me go ask a question. I know he's wearing a bandage on his leg. Do you want him already seated in the witness stand before the jury comes out?
I was going to ask that, Your Honor, if that is possible, that would be preferable.
We can do that, and so if you want to go ahead and make your way to the witness stand, Mr. Absher, you can have a seat right here, and we'll swear you in again in front of the jury once they enter the courtroom. Let me just ask a couple more questions now that I've got you here and you're still under oath. In addition to you having decided that you wish to testify, of course you sat through the defense case and saw the two attorneys that your client called as called as witnesses on your behalf. Were there any other witnesses you wish to be called that weren't called? I'm sorry?
You say so now.
What do you mean you had no say-so? I mean, obviously it's up to the attorney has the decision-making and strategy about the trial. Obviously that's why attorneys go to law school, but certainly you and she should discuss your defense and your case, and if there were witnesses you wanted to be called, and maybe she told you why they could or couldn't be called, and that's why I'm asking. Two attorneys have been called to testify in your case, and they did this morning. Were you satisfied that they were called?
Yes, ma'am.
Okay. Were there any other witnesses you wanted to be called in your case?
Your Honor, if I may assist just a little bit. There, from a strategy standpoint, there were some witnesses that there was a desire to call. However, from a strategy standpoint, we're trying not to open the door for certain things to happen. So and please, Mr. Absher, correct me if I'm wrong, I think those are the witnesses that you're thinking about. Is that true?
Yes, ma'am.
Okay. Well, let's just talk about it now, though. Who was that specifically? Do you have a name that you can give me?
Just people in the reference to this situation.
Well, like who? I mean, were there names that I read out on Monday or Tuesday
Yes,
to
Your
the
Honor.
jury?
Yes, Your Honor, and they were all disclosed. There was a strategic decision not to call certain ones, again, to not trigger a rebuttal case in this case. And again, please, Mr. Absher, correct me if I'm wrong, because I'm not exactly sure which witnesses you're referring to, but I think that those might be those. And please tell me if you're wrong, and there's some other that we needed to do.
Well, I'm just asking, who do you think?
I don't think there is anybody else that we need to be following, no, Your Honor.
Okay. Yeah, Mr. Absher, I mean, this is the opportunity, so you tell me what witnesses you wanted to be called in your defense.
I guess it don't matter, it's just what we gotta do right now.
Yeah, but this is your day in court. This is your trial this week. Are there any witnesses you wanted to be called that were not called? No? Okay. Are you satisfied so far with the representation of your counsel in the defense of your case?
Yes, ma'am.
Okay. Were there any exhibits or documents that you wanted her to introduce that haven't been introduced?
There was things I thought should be, yes, ma'am.
Like what?
Things that they said open doors to other things.
Okay. But can you tell me specifically, is there a piece of paper? Is there an object? Is there a document? Any kind of physical exhibit that you wanted to be introduced as evidence in your case that isn't being introduced?
I just don't want the jurors to think that they get showed these pictures like I was just dealing with regular career, like women with careers and stuff like that. It it was different type of level of women I was dealing with, and what was going on out there.
Okay. I don't know that I understood exactly what that meant.
I know that's the thing, I'm here a different caliber of woman, so.
Again, Your Honor, if I can, I think he's referring, the state and defense have extensively discussed prior bad acts that would or would not be entered into evidence, and if prior bad acts were entered, it would open the door for a rebuttal case. Again, I think that might be what Mr. Absher is referring to, is evidence telling what kind of character perhaps they had that we have discussed and chosen not to take that path so far. So, Mr. Absher, was there any other evidence that you can think of?
Okay. All right, then. Obviously, now you'll have the opportunity to testify and tell your side of this situation, but otherwise, are you satisfied with your attorney's representation so far?
Yes, ma'am.
Okay. Do you have any questions of me before we proceed? Okay. All right, then you understand you'll be seated here. We'll bring the jury out here in a moment. We're going to place you under oath again so that the jury can see that you will be under oath, and then your attorney will get to examine you, and the state will get to cross-examine you. And then your attorney will get an opportunity at redirect after the state has cross-examined you, just like it has been with every other witness that you've seen throughout this trial. Do you understand that process?
Yes, ma'am.
Okay, sir. Then why don't you go ahead and have a seat in the chair? Let's go ahead and bring the jury out.
Just stand up, though.
Yes, sir. All right, thank you, ladies and gentlemen. You may take your seats. All right, Ms. Edwards, you are going to call your next witness.
Yes, thank you, Your Honor. Defense calls Chad Absher.
All right, Mr. Absher. Then if you will just raise your right hand to be sworn, sir.
Do solemnly swear or affirm that the testimony you will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
All right, I do though need you to put up that microphone so we can all hear you.
Yes, ma'am.
Okay, thank you. And Ms. Edwards, you may proceed.
Thank you, Your Honor. Good morning, Mr. Absher. Can you please state your full name for the jury?
Yes, ma'am. It's Chad Absher, Absher.
Thank you. And how old are you?
37 now.
Okay. How long have you lived in Jacksonville?
All my life now.
How far did you go in school?
8th grade.
And before you were arrested in this case, were you employed?
Yes, ma'am, was.
What did you do for a living?
On my landscaping design business.
Okay, and what was it called?
T's all the above.
And T's a nickname that people call you?
Yes, ma'am.
Where'd that come from?
From just kids growing up.
So how long had you had that business?
It went legit in 2012. I started from a kid pushing more behind a bicycle in the neighborhood.
Okay, and when you say legit, what do you mean?
I was all the way living the right way, all on paying my taxes and everything.
From the business standpoint?
Yes, ma'am.
And have you previously been convicted of a felony crime?
Yes, ma'am, I have.
How many times?
2 times.
You've heard all the evidence about Ashlee Rucker and Lisa Rucker sitting here this week, correct?
Yes, ma'am, I have.
Can you please tell the jury how and when you met them?
Well, I actually met the kid first, little Joseph. I had my niece. I was done working one day. I was out. When I get done working in the evenings, I clean up my trailer and get my equipment ready for the next day to work. And while I'm doing that, I have my niece driving the mower around in the yard. She just like to ride it. And he came running up and he was hiding in the bushes. And I seen him and I was like, hey man, I showed him how to ride the other one. So I had them out there and that's how I met him. And then the sisters came after the fact because that was their grandma's house while it was across the street from where I was.
Okay, so They lived close to you at that time?
No, man, the grandma was across the street, so they seen their grandma.
Understood. Okay, so did you eventually form a relationship with Ashlee Rucker?
Yes, ma'am, I did.
And did you live together at times?
We have 4 or 5 houses.
And did her son Joseph live with you as well?
Yes, ma'am.
Did you love Ashlee?
Yes, ma'am, I did.
Did you think she loved you?
I believe so.
So how was your relationship? Was it always good, rocky? How would you characterize it?
It started out great. I never had a woman take me to a hotel room or take me on a cruise to the Bahamas.
How long were you guys together?
I think 3 or 4 years.
And so you said at first it was good. After that, how would you characterize it?
I mean, it kind of started turning around a little bit.
Rocky? Is that fair to say?
Yes, ma'am.
Would you guys break up often? Was it on and off, or did you just stay together the whole time?
Sometimes.
So there were times that you were not living together, correct?
Yes, ma'am.
And why wouldn't you be living together at that time?
It all depends on the situation.
Would you be broken up in all likelihood? During
There
this
was
time?
times, yes, ma'am.
And what was your relationship with your son Joseph like?
I thought it was great.
Did you love him?
Of course I did, like he was mine.
Was Joseph's father in the picture much at the time?
No, ma'am.
So did you, did you take that kind of role with him, or what kind of relationship formed with Joseph as a result of that?
I'm sorry. You said.
I know it's a long, convoluted question, I'm sorry. So, what kind of relationship did you form with Joseph?
You know, I try to teach him how to drive everything that I own. I try to take him fishing.
And so Joseph was included in a lot of the things that you did?
Yes, ma'am.
And,
Anything he was interested in.
and so he was also included in a lot of things you and Ashlee did together?
Of course.
So what was your relationship with Lisa Rucker?
Lisa was, I mean, it is what it was. She came along with the sister. Sometimes she had problems, and
Did she live with you?
yes, ma'am. Sometimes in a few places.
So did she live with you and Ashlee at all the places, or just some of them?
Not just a few. She would stay, and then she'd get another boyfriend or something.
When Lisa Rucker did live with you and Ashlee, did her son Colton live with you as well?
Yes, ma'am, we did.
And did you have a similar relationship with Colton that you did with Joseph?
I did.
So, I want to move to the day of the incident. The shooting involved in this case took place in the early morning hours of October 31st. And on that day, you were living with Lisa, Ashlee, and her sons, correct?
Yeah. Well, I went and stayed. I stayed there at night.
So you were not living there. Correct me, please.
Yeah, I just stayed there at nights, ma'am.
Okay. Why were you not living there at the time?
It was just best for us the way we had it worked out.
So where were you living?
I had another place.
Where did you spend most of your night?
With Ashlee.
Did you have a key to their apartment?
Yes, my mom did.
Were you allowed to be there even when they weren't there?
Of course.
So in October of 2017, were you working your landscaping job at that time?
The day when everything went down?
Yeah. Well, around that time, were you working?
Yes, ma'am.
Mr. Absher, did you shoot Lisa Rucker?
No, ma'am, I did not.
Did you shoot Ashlee Rucker?
No, ma'am, I did not.
Okay, let's back up. How did you and Ashlee get together that day?
Which day, ma'am?
I'm sorry, the day of the incident.
Early.
I'm sorry?
I'm trying to think exactly. I probably took her lunch and then she got out of work. She like, gosh,
About what time was that?
her getting off work.
Yep.
She know. She wanted to tinker around in the house that day. She liked to fix stuff up, you know.
So can you explain to us what happened that afternoon and evening?
I really still don't know for sitting here this long.
Sorry?
I still really don't know for sitting here this long.
Okay, well let's get specific. Was there pizza there that evening?
Yes, ma'am.
Okay. Who got the pizza?
We went and got a pizza.
I'm sorry?
We went and got a pizza.
When you say we, who went?
Joseph, Ashlee, and I.
And were you drinking that day?
Of course.
Of course. What did you drink?
At that time, I drank Fireball.
Okay. How much did you drink, would you say?
On average, or
No, that day.
3 or 4 pints by the time we was getting pizza.
And were you using any medication?
Yes, ma'am.
What medication were you using?
I took Percocet and Adderall throughout the day, and then at night I took Xanax.
Okay. And do you experience pain in your legs?
Yes, ma'am, I do.
Okay. And was that the purpose of the pain medicine?
Yes, ma'am.
When did you take those pills?
Throughout the day.
So would you say one was early afternoon? Like how? Can you space them out for us a little bit?
Yeah, I can tell you exactly.
Okay, please do.
In the morning when I get up, I have a cup of coffee. I take 2 Percocet, Adderall. I get going. I get lunch. Got my trailer. My guys working. About 2, 3 o'clock, probably take 2 more Percocets. Keep working. Then by 5, 6 o'clock, it's time to wind down.
And did you experience any kind of injury that caused you pain?
Yes, ma'am.
Can you please explain that to us?
Which incident on my body you talking about?
Well, one that you might take medication for.
As far as me being prescribed medicine?
No. What is it that you take medication for? What are you shooting?
Well, I got a hemorrhage for my legs.
How did Lyle Scheidemann wind up at the apartment?
Showed up with Lisa one day,
How long did you know him?
a couple days. I didn't really know him. He was there.
How long had you been coming to the apartment?
About 3, 4 days.
Were you friendly with him?
We nod at each other. Mostly he stay in our room.
Was he drinking?
On one occasion.
That evening, we're talking about that day.
Yes, ma'am.
What did you see him drink?
He was drinking them 4 Locos.
Okay. Was Lisa drinking?
Not 100% sure.
What about
Ashlee did with a credit card.
Okay. And so who ate it?
Well, of course, the kids, and then whoever else got a piece.
Who was the first one to go to bed that night?
Probably our room.
I'm sorry, probably our room, is what you said?
Yes, ma'am.
Okay, so who stays in our room?
When I say it like that, excuse me, I got, at the condo over here, I got Ashlee and Joseph this room, and Lisa and Colton's in the other room at the time. And then she's got this dude over there. But the baby was fine, he's just watching TV.
So who is it in your room? You, Ashlee, and Joseph,
Joseph,
correct?
yes, ma'am.
And are you saying you three were the first ones to go to the bedroom?
Yes, ma'am.
Where did you lie down in Ashlee's room?
On the bed.
Okay. And Ashlee slept in the bed too, correct?
Of course, she slept in the middle.
Okay, and where did Joseph sleep?
He was in the cubby hole.
What's the cubby hole?
He liked to fold pillows up and put it in the corner right there, and he made him a little spot there, you know?
In the same bed with you guys?
Of course.
Do you remember seeing Joseph come in the room that night?
He was already in there.
So did you actually get to sleep at all that night?
Pretty sure his nose was off.
How were you dressed when you went to bed?
It was random. I still had one set of pair of shoes on and my pants. That's not it. But I got somebody different in the house too, so
How did you feel when you went to sleep?
Xanax just knock you out.
And so were you and Ashlee arguing earlier in the day?
On what specific day?
That same day of the incident concerning car keys?
All right. Yes, ma'am.
In your mind, was that argument resolved?
She got what she wanted, the car key. Of course, she got what she wanted, and it was that. Yes, ma'am.
So after you went to sleep, what do you remember happening next?
I got woke up to being beat in my sleep.
Who was beating you?
Lyle was on top of me.
Who?
Lyle
What was he doing?
beating me in my face.
Anybody else?
I said in deposition, or not deposition, excuse my language, told the detectives about Ashlee, but I don't want to tell, no, we just gonna leave it at that.
Okay. Did Lyle have any weapons?
Yes, ma'am, we did.
What do you remember him having?
The people that lived at the place before, because they just got the place, and when we signed the lease, I told them I didn't want to be on the lease.
Wait, no, I'm sorry. What the question was, do you remember?
I'm sorry, I'm sorry.
No, it's okay. Do you remember whether Lyle had any weapons?
Yes, ma'am.
Okay. Do you remember what weapon he might have had?
It was a baton. The one that the police wear that hang on the side, you sling it out, it's metal. It's about that big whenever you got it balled up in your hand.
Did you see a knife at any point?
Yes, ma'am, I had a fixed blade I kept on my belt that I cut my weed eater string with.
So what did you do?
I didn't have the knife in my possession.
Understood. So at this point, you're telling us that Lyle is beating you. What did you do next at that point?
I got up out of the situation. Lisa was right here, Lyle was on me, and Ashlee was this side. Like, I come up out of this situation, I got up on my feet,
Okay, and where'd you go?
I went out towards the living room.
And did the fight end at that point?
There was never a fight.
Well, the Lyle beating you, did that end at that point?
Yes, ma'am.
Were you hurt?
Got my teeth and everything out. I mean,
What injuries did you sustain? Your tooth? What else?
that's 2 teeth, ma'am.
2 teeth, my apologies, 2 teeth.
Mhm.
What other injuries did you sustain?
My forehead, you know, my nose, stuff like that.
You saw the pictures that the state presented of you earlier yesterday?
Now they clicked through them too fast, so the jurors couldn't see.
Oh, stop it. You saw the pictures before.
Yes,
Were those pictures an accurate representation of what your injuries looked like that day?
yes, ma'am.
Were you bleeding?
Yes, ma'am, I was.
Where were you bleeding from?
On my face, mouth, nose.
Do you know where your teeth are?
One of them was in the bed. The other one was in my pocket that the detective had, or the police officers.
So once you got up out of the room and walked out in the living room, what did you do next?
I was getting my stuff together. I was just on leave.
What was Ashlee, Lisa, and Lyle doing at that point?
That boy ran out of the whole place.
And when you say that boy, you mean Lyle?
Yes, ma'am, I do. Lisa was standing by the bar. Ashlee was following me around because my face was just dripping blood, so I'm just getting my stuff. And she was wiping up the blood.
So did you get a chance to gather up any clothes or any other things to leave?
I'm sorry, ma'am.
Were you gathering up clothes?
And my shirt, jacket, keys, and phones and all that.
What were you getting ready to do?
I was just gonna leave.
Were you aware that Lisa had called 911 at that point?
No, ma'am.
As you were leaving, did you have a rifle in your possession?
Yes, ma'am, I did.
And were you aware that a rifle was in that apartment?
Yes, ma'am, I was.
Do you know how the rifle got into the apartment?
I put it in there.
Okay, and when did you do that?
Probably around the time they moved in.
Did it belong to you?
Yes, ma'am, it did.
And how long had you owned it?
I don't know exact days or time.
Roughly?
A couple years.
Did both Lisa and Ashlee know that you owned this rifle?
Yes, ma'am, they did.
And then had they seen it inside the apartment before?
Yes, ma'am, they did.
Had you ever tried to hide it from them?
No, ma'am.
To your knowledge, had they ever fired it?
Ashlee.
Did either of them ever object to you bringing it into the apartment?
No, ma'am.
So on this day that we're speaking about, October 31st, where was the rifle?
You mean when this ended, the whole everything went down?
Yes, sir.
It was behind some couch cushions.
Did you know it was there?
I don't remember exactly.
Did you think it was somewhere else?
Sometimes it'd be under her mattress.
So did you bring it with you into the apartment that day?
No, ma'am, it was there.
So do you have any idea how it got behind the couch cushion?
No, ma'am.
Is that where it was usually kept? bullets were in it?
Probably this couple.
Do you know what the full capacity was of the magazine?
I'm sure probably with the magazines full and the gun full, probably 17 or something.
So what happened as you were trying to leave the apartment after the scuffle with Lyle?
I walked between Ashlee and Lisa.
Well, where were you walking out of the apartment at this time?
Towards the bar and between the couches. The diagram Mrs. French had over here the other day. I don't got nothing to show the people today, but I'm just, I don't
Just
got no.
explain it, it's fine, go ahead. You were walking out in between the couches.
I was walking in between, Lisa was up toward the bar and Ashley was in between two couches.
And then what happened when you walked out there? Did anyone point a rifle at you, Chad?
Yeah, Ashley brought it up from behind the couch.
What did you do? Well, what happened?
Lisa got shot.
How did that happen?
Ashley was trying to shoot me.
So Ashlee had the rifle pointed at you.
Yes, ma'am.
And where was Lisa standing at that time?
At the bar, where all the blood that they seen, the big pile of blood, that's where she fell at.
And where was that into relation to where you were standing?
To what you, I don't know.
Where was Lisa in relation to where you were standing?
Behind me,
And where was Ashlee?
in front of me.
So when Ashlee pointed the rifle at you, what'd you do? Were you able to do anything?
It was a good, wasn't a situation like it was all in movement, everything was just going.
So how fast? How much time would you say passed from the time that you saw Ashlee pointing the gun at you to Lisa getting shot?
Do you want me to just demonstrate it?
Well, I'm asking how much time first.
It's a matter of split seconds.
And then what'd you do after the shot?
I spun around and grabbed the gun.
How did you feel at that point?
Confusion, shock. I'm still bleeding. I done got beat up. I'm half drunk. I'm on sleep meds.
Why didn't you just run out of the apartment at that point?
Cause I ain't like some people. I don't run off and leave them.
How close were you to Ashlee when she shot past you?
It was in probably 2-3 foot area.
At this time, Your Honor, I would ask if you'd be able to just step down to the side. I'm going to ask you to demonstrate exactly how this went.
Okay.
Thank you, Your Honor, and if I may approach you.
I can get up now.
Yes.
Okay, stay right here, back here. If you can just show us how you and Ashlee were struggling over the gun.
We're in the wrong kind of corner here.
Okay.
I would just ask you, Mr. Absher, since you're not on the microphone now, we need the court reporter and the
Oh,
jurors to
wow.
hear you. Just speak up, okay?
Yes, ma'am. My voice is coming.
I understand.
Do your best.
I gotta make a,
Can
Well,
I use
show
things
us.
to make a crime scene here? Or?
Yes, go ahead and, no, just demonstrate from there. Show us where everything is.
Well, this would be the bar of the place. This would be one of the couches. And right here would be going towards the front door. In between here is another couch that you'll see in the diagrams that Ms. French had up. Ashlee, as I came through here, Ashlee was coming this way because I'm just pouring blood at the time. And behind this couch cushion, she held the gun. From this point, Lisa gets hit. And I'm like this, and I spin around and grab the gun. And when I twist the gun and yank it, her hand goes around to stop, and she drops.
Okay, thank you, Mr. Absher.
You want me to sit down now?
Yes, please.
Yes, please.
So you explained that you and Ashlee both had your hands on the gun at the same time, is that correct?
Yes, ma'am.
Okay, can you explain where her hands were and where yours were on the gun at that time?
Well, obviously, I can't show you all. Could you, Miss French?
Mr. Absher, just please explain, if we're starting from the bottom, if you're holding onto the gun, where were your hands in relation to each other? We can just explain about relation to each other.
Grab towards the back of the stock, because if you notice what the gun was yesterday, where the stock, the grip comes down towards the bottom, and it's got the area, but it's short. Where she had it this way, I grabbed from this way and pushed the barrel away from me. And that would cause her hand to switch around like this.
And what were you trying to do at that point?
I was trying to get it, make it everything safe at the time. The gun just went off. I was just trying to get the gun from her.
So did your hand or finger ever touch the trigger?
No, ma'am.
So you said that the first shot went past you and hit Lisa, correct?
It went behind me,
Okay.
not in front.
I'm sorry?
You did it in front, but it went behind.
I'm sorry, okay, and hit Lisa. How did it fire a second shot then? Is the gun able to just, can you explain to us what needs to happen before a second shot gets fired?
It's just ready to go.
So does it need to be cocked at all?
I think the initiation, the first time, and then it cocks itself as it goes.
Okay, so does the safety need to be moved to fire a second time?
If it's on safety.
Okay, but if the safety's off and it's fired once already, would a safety need to be removed again in order to fire?
No, ma'am.
So it doesn't work essentially like a pistol then, would you say?
Yes, ma'am, pretty much.
And did Ashlee know that? Had she fired that gun before?
Yes, ma'am.
And are you aware she had any experience with other firearms besides that one?
I'm not aware of that, no, ma'am.
Did that rifle have a pretty strong kickback on it?
Not really. Not too bad.
And what sort of trigger pull would you say it had?
I mean, from the first, it was a little, it's not like, it wasn't just a hair trigger. It wasn't easy. It was, I mean, if you was spontaneously, because it was rapid, you had to pull the trigger for it to keep firing and then keep firing.
So what happened after second round was fired? Hitting Ashlee. What'd you do? Did you realize you were shot?
Yes, ma'am.
What did you do?
I left them.
Why did you leave?
Because I was a coward.
You were scared.
Yes, ma'am.
Did you take the rifle with you?
Yes, ma'am, I did.
Why didn't you call her home?
I didn't know what was just doing, what I was doing.
So where did you go?
I walked up some back streets. I walked up lanes to London apartment and walked to a lady's house. Asked her for a rag to wipe some of the blood off of me.
And then where'd you go after that?
From there, I got back towards the other place in the neighborhood.
How'd you feel at that time?
I mean, what do you mean how I feel at the time?
Were you scared? Were you anxious? Were you happy? What was your feelings at that time?
I was confused. And
Were you trying to hide from the police at that point?
I'm sorry.
I'm sorry, were you trying to hide from the police at that point?
no, ma'am, not at that point.
So did you end up at your friend's house?
As in,
Where did you end up going? Where were you arrested at?
in the neighborhood.
You heard the officers explain how you were arrested while you're here in court, correct?
Yes, ma'am.
And was that all true for the most part?
Yeah, they sent a robot in there.
Did you know before the police got there if they were coming to the house or not?
Yes, ma'am, I did.
After you were arrested, did you talk to the detective?
Yes, ma'am, they took me to the memorial building.
And you did an interview with Detective Minash?
For 7 hours.
And were you arrested at the end of that interview?
Yes, ma'am, I was.
Were you afraid Ashlee was going to shoot you when she had the rifle?
Yes, she missed.
But why were you afraid she would shoot you?
I had been messing around with Lisa.
Thank you, Your Honor. I have no more questions.
All right, cross-examine.
All right, so let's get this straight, Mr. Absher. You're a two-time convicted felon.
Yes, ma'am.
However, you state you owned that high-point rifle, correct?
That's right.
And you're not allowed to own a firearm, are you?
I sure am not.
But you did anyways.
Yes, ma'am, I did.
Okay. And you kept that firearm, you stated, at the condominium that was being rented by Lisa and Ashlee Rucker, correct? Correct?
That was on the lease. Yes.
Okay. And you did not keep it in a couch cushion or seat cushion, did you?
It was at the time.
I asked you where you kept it. You did not keep it in a couch or seat cushion, did you?
It was in the bedroom normally.
Okay, so you did not know where your rifle was, did you? At that time?
At what time?
The time that you were looking for it in the condo?
The time I was looking for, I was never looking for it.
You weren't looking for your rifle? What were you looking for then when you were pacing around after you and Lyle got into a fight?
Just picking up my things, my jacket, getting my keys and phone and everything together.
Right, and that would include your rifle because that's one of your things, isn't it?
That stayed at the house.
But it's one of your things, isn't it?
There was a lot of things at that place that was mine.
I asked you can answer my questions, Mr. Absher,
I am answering your question.
and I said, isn't it one of your things?
You've been waiting for 5 years to do this, ain't you?
You do
Okay,
not.
we are
answer
not,
questions.
let me just stop both parties right here, right now. This is not gonna be an argument. This is gonna be a question, an answer, and a question and an answer. I am not going to put up with
Yes, ma'am.
argument between both sides. So ask your question, let him finish his answer. You answer your question, and then she will ask the next question.
The rifle was one of your things, wasn't it?
Yes, it was.
And you weren't expecting to see the rifle come from a couch or a chair cushion, did you?
Mine.
Okay. So let's start from the beginning a little bit. You had, on October 30th, 2017, Ashlee Rucker's black Mercedes, correct?
Yes, I did.
And Ashlee worked full-time, didn't she?
At what job?
She worked full-time, didn't she?
Yes, ma'am.
Okay, and she worked multiple jobs, didn't she?
Yes, ma'am.
Okay, and you dated her for approximately 4 years, didn't you?
3, 4 years, yes, ma'am.
Okay, and you got to know her son Joseph, correct?
Of course.
But on October 30th, 2017, the two of you did not live together at that Cedar Creek condos, correct?
I stayed the night there.
You did not live there, correct?
No, ma'am.
In fact, you lived at a different place, didn't you? The address of 6366 Woodman Drive?
Yes, ma'am.
Because that's the address you gave to police. That's where you live, correct?
Mhm.
Is that a yes for the record?
Yes, ma'am.
Okay. And you didn't give them the Cedar Creek condo landing address, did you?
No, ma'am, I did.
Okay. And you stated that you went and picked Ashlee up from work, right?
Yes, ma'am.
And you didn't work that day, did you?
No, ma'am.
And I think you also stated Ashlee did several things for you, didn't she, financially?
I never said nothing about financially.
You talked about a cruise, you talked about,
Yes, ma'am. Yes, ma'am. That was through the job she had at the time.
right, but she did things for you that involved money, correct?
Yes, ma'am.
She was a caring, giving person, wasn't she?
Of course she was.
Okay. And that's why you dated her for 4 years then, didn't you?
Not from nobody's money. No, I did not.
No, that's not what I meant. And I
Well, I just-
apologize if that came across that way. I meant for being a caring, loving person. That's why you dated her for 4 years, correct?
Yes, ma'am.
Okay. So, and throughout the day, you go and pick her up. I think you'd already stated that. And then at some point, the two of you are arguing about her car. Is that a fair statement?
The key.
Right, because so that would involve her vehicle, wouldn't it?
Yes, ma'am.
Okay. And you actually left in her vehicle, didn't you, from the condominium earlier in the evening after you had picked her up?
She knew that.
I didn't ask that. Did you do it?
I did. Yes, I did.
Okay. In fact, when you went to go leave the condo at that particular time, that is when you saw Lisa Rucker and Lyle Scheidemann and Colton coming back home for the day. Is that correct?
Sure, yes, ma'am.
Okay. And then at some point, you arrived back at the condominium and you were hungry, aren't you? Yes or no?
Sure, yes.
Okay. And you all decided to get some pizza. Is that accurate?
That's what the kids wanted.
Yes or no?
Yes.
Okay. And that is for everyone that is now at the condominium. Is that accurate?
Yes, ma'am.
And just to be clear, the only individuals that are at the condominium on the night of October 30th are yourself, correct?
Yes.
Okay. Lisa, Lyle, Colton, Joseph, and Ashlee. Is that a fair statement?
Yes, ma'am.
so there's no other individuals except for the 6 of you. Is that fair to say?
Yes, ma'am.
Okay. Just want to make sure that we all are in agreement with that. So you all eat some pizza, don't you?
At some point, yes, ma'am.
And you've already agreed that you were drunk on October 30th, correct?
I stayed drunk.
You stayed drunk, okay. And so you're drunk, correct, then on October 30th,
Yes, ma'am.
okay? And you were drinking Fireball, correct?
Yes, ma'am.
In fact, the Fireball that we see in the freezer is your Fireball bottle, isn't it?
Of course.
Okay? So is that a yes?
Yes, ma'am.
Okay. And I think you and State Law had a drink with you, didn't he?
I didn't let people drink out my bottle.
No, I mean, but did he have a drink with you? I didn't ask you, I didn't,
He was drinking for locals.
okay, I didn't ask you if he was drinking Fireball, I just asked you, did he have a drink with you?
Yes, ma'am.
Okay, and the two of y'all had that drink on the porch?
I don't remember exactly where we was.
Okay. Were you in the condominium?
It was in the vicinity, yes, ma'am.
Okay. It was getting late at this point, wasn't it?
It's probably dark.
Okay. And at some point, it's time to go to bed. Are you tired at this point?
Yes, ma'am.
Okay. And you agree that you and Ashlee and Joseph are all in Ashlee's bedroom. Is that a fair statement?
Yes, ma'am, it is.
Okay. And then Lisa, Lyle, and Colton are doing what they're doing. Is that a fair statement?
Yes, ma'am.
Okay. So it's your testimony today. Then you're sleeping in your bed with Ashlee, and all of a sudden you just get woken up to people beating you. Is that your testimony today?
What do you mean my testimony today? That's what it was from the beginning.
Please, you don't get to ask the questions. Just please answer my questions.
You're trying to trick me out.
No, I'm not. Please answer my questions.
Yes, ma'am.
Okay. So, with no provocation, you get woken up to 3 adults beating you. That is your statement today, correct?
One for sure. I'm not even going to talk about the girls.
Is that your statement that 3 people were beating you up unprovoked, and that's what you got woken up to?
Yes, ma'am.
Okay. Where was Joseph?
He was in the bed when I laid down.
Okay. Well, where did he go? Was he there when you had 3 adults beating you in your sleep?
No, it was not.
Okay, so do you know where he went to?
To Lisa's room.
I mean, I'm not asking you to assume. If you don't know the answer, it's okay to say, I don't know. Do you know where he went?
No.
Let me ask you this. Did you see him leave the bedroom?
I don't remember.
Okay, that's fine. So, and I think you also stated earlier that from being beat up on the bed, you were bleeding, correct? Isn't that what you stated a moment ago, that you were bleeding on the bed?
I didn't say I was bleeding on the bed.
You didn't say you were bleeding after being beat
I
up?
said I was bleeding. I didn't say I was bleeding on the bed.
But that's where you got beat up though, right?
That's right.
Okay, so let's look at a photograph here.
All right.
So looking at State's Evidence 1LL, we don't see any blood on the bed, do we, Mr. Absher?
Of course we don't.
But that's where you were beat up, and that's where you became bloody, isn't it?
How long does it take for blood to run out of the body?
Again, I'm not here for you to ask me questions,
I
sir.
got to my feet before it got blood on the bed, yes, ma'am.
Okay, but you agree there's no blood on this bed?
No matter what.
Okay. And then you mentioned a moment ago also too that per your testimony, it takes a while for blood to occur. You don't see any other blood on the floor, do you, in State's Evidence 1LL?
No, I do not.
Okay. So then when did you start bleeding?
I'm sure as soon as it started.
Okay. So if it started in the bed, wouldn't you agree there should be blood in this bed?
No, I will not agree to that.
Okay. So you're just gonna contradict yourself?
I didn't contradict myself.
Okay. All right, so are you then disagreeing that the fight between you and Lyle commenced in the bedroom and then ended in the hallway? Are you disagreeing with that?
It was never a fight.
Okay. So you never threw any punches at Lyle?
No, ma'am, I did not.
So then how did Lyle sustain his injuries?
Where was he injured at?
Okay, well, let's look. You agree you see some scrapings on his right hand?
Yes, ma'am, I do.
So you agree that that's an injury?
Yes, ma'am.
Okay. And then also too, you see some markings on the palm of his left hand. You agree that's some injuries as well?
No, I will not. It looks like dried up blood.
Okay. And then also looking at State's Evidence 3D, you see some lacerations as well going down his right arm. Would you agree?
Can't say it's a laceration, no, ma'am.
Okay. But you do agree you at least see some injury to Mr. Scheidemann, correct?
There's blood on him.
Okay, well, so you disagree with me. You don't see any injury to Mr. Scheidemann?
His hand, yes, ma'am.
Okay, so you agree you at least see some injury then, correct?
Yes, ma'am.
Okay. And you agree then that those injuries occurred when you and Lyle were in a fight, correct?
I'm assuming.
Okay. And you agree that the linen closet's door got broke, correct?
No, ma'am.
Okay, you don't agree that the linen door was broken?
Why would I agree to that?
There's photograph evidence of it. You disagree with the photograph evidence?
Of a door that's moved in the blood apartment?
Yes. You want to see some, and what about the further parts that's wrong with the linen closet that were broke?
Mm-hmm.
You disagree with that photographic evidence?
I'll pull it up.
Okay, let's pull it up. Can you see State's Evidence 1 impound defendant?
Yes, ma'am.
Okay. You agree that you see some paper towels and some things that have fallen here in the linen closet? Would you agree with that?
I see stuff on the floor, yes, ma'am.
Okay. All right, let's get to a couple other pictures here. So looking at State's Evidence 1GG, would you agree there's damage here to the linen closet?
Wouldn't call it damage.
Okay. What about looking at State's 1HH? You see all the different, you've got shelves on the ground, you've got parts of the shelves also on the ground, there is damage then to the door. Do you agree that that's damage?
Yes, ma'am. You can assume that that's what it is.
I'm not asking you to assume. I'm asking you, do you agree that this photograph, 1GG, shows damage to the linen closet?
Yes, ma'am.
I apologize, 1HH for the record. But you're saying that the fight between you and Lyle didn't happen here by the linen closet?
No, ma'am, I did not.
Okay. So, are you saying, then how did this damage occur?
I honestly can't tell you what's going on right there.
Okay. But you're there almost every day though, right?
That's right.
Okay. So if you're there almost every day, then how do you not know about damage to the linen closet?
I don't look in the linen closet when I'm there.
Okay. You agree there's fresh blood there too, don't you?
No, I do not work.
Okay. Let me point it out for you. See right here, I just circled by that white towel. You don't agree that that looks like fresh blood?
That's a towel.
Okay. I'm not talking about the white towel. I'm talking about what's beside it to the right that I just circled. You don't see the fresh blood right there?
No, ma'am.
fast forward real quick here. Do you see the further damage and then some blood by EV6 and states 1 quadruple C? Do you still disagree that that's not blood?
I see some napkins that was cleaned of blood and put in there. That's
Okay.
what I see.
So you're saying it was staged?
You're good.
You said it was put
No.
there, so I'm just asking you, do you think it was staged?
I don't know, honestly, man.
Okay. All right, let's look at state's evidence 1 quadruple D. Do you agree you see blood there?
Yes, ma'am.
Do you agree it looks fresh?
Yes, ma'am.
Okay. That's because you were also bleeding, weren't you?
Yes, ma'am, what?
Do you agree that that could be your blood?
It's possible.
Okay.
That's my blood.
So you do agree in 1 quadruple F that that's your blood?
That's where I spit the blood out of my mouth when I first got out of bed.
Okay. So you're saying that, this is your blood?
Yes,
You're comfortable with that?
I'm very comfortable with that.
Okay, all right. Because again, you were fighting, started around this door frame, didn't it, look like?
I did not start in bed.
Okay. But you agree, the door we're looking at in 1 quadruple E, that's the door,
To Ashley's bedroom.
thank you, you knew where I was going, didn't you? Now, looking at state's evidence 1 quadruple G, do you agree, and then I'll show you a little bit closer view here, 1 quadruple H, do you agree that that looks like fresh blood on those towels?
Yes, ma'am.
Okay, you agree that potentially could be yours, or Lyle's blood?
It's probably mine.
Okay, and that was because you and Lyle were fighting?
It was never a fight.
Okay. So you're saying you just let Lyle beat you down and you did nothing? Is that your testimony today?
No, ma'am.
Okay. When you say there's no fight, that means you didn't do anything in return, correct? You agree with me?
He ran when I got out of bed.
Right. But when you're saying there's no fight, you agree then what you're stating is you did nothing and you allowed Lyle just to beat you, correct?
I was asleep.
It's a yes or no answer.
Yes, yes.
Okay. And you didn't have any problems with Lyle prior to those early morning hours, October 31st, did you?
No, ma'am.
In fact, 'cause the two of you only knew each other a few days, right?
Yes, ma'am.
So isn't it odd that then Lyle would just come to you in the middle of the night to beat you when you've never had an issue? Don't you agree that's odd?
Yes, ma'am.
Okay. And that's because it didn't happen that way, correct?
That's what you say.
Yes or no answer?
No.
Now, you know that Lisa called 911, correct?
No, I do not.
So you did not know she called 911?
No.
So until you were arrested, that's when you're stating that you learned about the 911 call by Lisa?
Did you say that again?
After your arrest, is that what you're stating today, is you learned about the call then by Lisa?
That's the first I've heard him call, yes.
Okay. Oh, you're saying through the pendency of this case, that's the first time you've heard the call?
Yes, ma'am.
Okay. You agree, in the back of the call, you can hear Lisa saying no, no, no. Do you agree that you can hear Lisa say no, no in the call?
Yeah, I guess.
I'm not asking you to guess. Do you remember that?
Can you play it again?
Sure. I'll play a portion before we get to that. So in thinking about the 911 call, do you agree that Lisa says there's been an altercation? Do you agree with that? Or do you need your memory refreshed?
You're about to play it?
Do you need your memory refreshed?
Yes, ma'am.
Okay. I'm just going to do 2 short portions. I've already got them timestamped ready for you.
Ready for me.
There's an altercation, I'm asking.
Okay, so I just paused it at 19:06. So you agree that Lisa is saying no, correct?
Yes, ma'am.
And you agree that there are males in the background telling her to not talk on 911, correct?
I was listening for the no. I wasn't paying attention.
Okay, we can move on past that. But you agree she tells then also there's an altercation?
Yes, ma'am.
Okay. Now altercation, that indicates 2 people involved, at least, correct?
Yes, ma'am.
Okay. Now, at this point, you do agree that you were pacing the condominium, correct?
Pacing?
Okay, you're going around in various places in the condominium, correct?
Getting my jacket, my shirt, phones, my keys, stuff.
Okay, and then even in fact, you walk out to the porch area too, don't you?
Yes, ma'am, I do.
Okay. And that's because you're being told to leave by Lisa, correct?
No, ma'am, I wasn't.
Lisa never told you to leave?
I didn't say that. That's not why I walked to the porch.
I'm asking you another question.
But you asked me one first.
I'm asking you, did Lisa tell you to leave?
Yes, ma'am.
Okay? And in fact, Ashlee wanted you to leave as well, correct?
I don't recall.
You don't recall? Okay. She didn't want to be around you though, did she? At this point in time.
I don't remember.
You don't remember? Okay. And Joseph's not known to, you've known Joseph for several years, correct? At that point in time? And Joseph isn't known to lie, is he?
Yes, he is.
He is. Okay, so that's your testimony today?
No, when I first said that he don't lie, it was because of the fact that I wasn't about to let nothing happen to them, and I'm not going to say something bad against them.
He was 9 years old at the time, correct?
Right?
All right, and Colton was 4 years old?
Yes, ma'am.
Okay. So now you're saying that little Joseph, 9-year-old, is just a little liar. Is that what you're saying today?
He was at the time. Yes, ma'am.
Okay. And then you didn't know that Joseph and Colton were still in the condo, did you?
No, ma'am.
In fact, you thought that they had left with Lyle, didn't you?
I don't know where nobody was at.
Right, but you didn't see Lyle, did you?
Of course not.
He left, didn't he?
Yes, ma'am.
Okay. And you didn't know where he went, did you?
No, ma'am.
And you didn't know that Colton and Joseph, where they were located, did you?
Not at the time. No, ma'am.
So at this time, you think it's just you, Lisa, and Ashlee in the condominium, don't you?
Yes, ma'am.
Okay. And you're not happy that you just got beat up, are you?
No, ma'am.
And you're drunk too, correct?
Yes, ma'am.
Okay. And it's kind of embarrassing, isn't it, to get beat up?
I've been beat up most of my life. No, it's not.
Okay, so you weren't embarrassed?
No, ma'am.
Okay. And you agree that Lyle got the better of you, correct?
I guess you'd say that. Yes, ma'am.
Okay. And Lisa's on the ground cleaning up blood, isn't she?
No, she's standing by the bar when I come through.
Okay, so you're saying that she wasn't cleaning up blood?
No, she had a phone in her hand.
Okay. Well, where did the Windex and the rack come from?
I don't know.
Could you please repeat? I'm sorry.
I said I'm not sure.
Okay. But you agree that there's Windex and a rag on the floor, correct?
It's in the picture. Yes, ma'am.
Okay, and that's exactly, and just make it very clear. And you agree, though, in State 7's 1 pp, we do see a Windex bottle in a blue rack, correct?
Yes, ma'am.
And you do agree this is where Lisa was located, correct?
Yes, ma'am.
The time that she was shot, correct?
Yes, ma'am.
And you're stating Lisa did not shoot herself, did she?
To ma'am.
But you're denying shooting Lisa, correct?
Yes, ma'am.
Okay. And you're stating that Ashlee, the older sister, who's always cared for Lisa, shot her, correct?
Yes, ma'am.
Because I think you stated earlier as well, that by dating Ashlee, that kind of also included Lisa. Isn't that what you stated earlier?
Towards morning, yes, ma'am.
Okay. But yet, now all of a sudden she's going to shoot her own sister? That's what you want the jurors to believe?
I'm not trying to make them believe anything.
That's what you're saying today then, aren't you?
I'm saying that the bullet was intended for me.
Okay. You don't know what Ashlee was doing though, do you?
At what time?
Okay. You're saying that Ashlee was just out of the blue going to shoot you?
Yes, ma'am.
Okay. Even though you're being asked to leave?
Yes, ma'am.
Do you agree that doesn't make sense, correct?
Of course.
Okay. But do you agree then, looking though, and I'll move on past this then, states 1 PP, this is where Lisa was shot. You don't disagree with that, do you?
No, ma'am.
Okay. And I think you stated that your rifle that you're not allowed to own was in one of the couch cushions, correct?
That's where it was at the
Okay.
time of this.
And I think I just wanted to flush out. Are we talking about the larger couch? Are we talking about the love seat? Or are we talking about the chair?
It was behind the first couch here, not the one in front of.
All right, let me just pull up a picture. I just want to make sure we know exactly what you're saying. Are you talking about states 1 AAA? Is that where you're stating that Ashlee had pulled out your rifle?
Behind the pillows.
Is that a yes then?
Yes, ma'am.
Okay. And we see, I think, what, 5 pillows? Is that accurate? 5 pillows, is that what you see as well?
Yes, ma'am.
Okay. So you're saying behind these pillows, that's where Ashlee pulled out your rifle, correct?
Yes, ma'am.
Okay. And where are you standing at this time? Can we see it in State's Evidence 1 AAA?
I'm more towards where.
You can draw, actually. Go ahead and touch it.
Okay. I'm in this area. Ashlee's here. And this is where Lisa's over in here.
Okay. All right. So you're stating you're pretty close then to Lisa, correct?
Yes, ma'am.
Okay. And then you're saying Lisa's standing up, correct? Not on her hands and knees.
She was leaning against that. That's a bar. This right here is a bar.
Correct? Mm-hmm. All right. And are you standing up?
Yes, ma'am.
Okay. And how is Ashlee positioned?
She was coming through these. She would come this way, wiping blood up as I was going out to go to the front door.
Okay.
She would come up. When she came up from right here, she leaned up and had that in her hand. Was shot this way. It's Lisa.
Okay.
Right here.
Well, I'll pull it back. So I just want to come back a sec. You're saying that Ashlee's cleaning up blood in front of the love seat?
Somewhere right through here. Actually, there might be a speck right there. I'm not sure.
Okay. Well, you agree though, in the interior of the couches there is no blood, correct?
Of course not.
Okay, but so how is Ashlee cleaning up blood there if there's no blood there?
So I came down through here.
So you're saying you're dripping blood through there,
Yes, ma'am.
and that's why she's cleaning blood there?
Right.
But isn't the blood concentrated in the hallway?
Which area?
The hallway leading in back to Ashlee's bedroom. That's where all the blood is, don't you agree?
It's back there, yes, ma'am.
Okay, well, wouldn't that be the locations of where someone needs to clean up blood?
It's just, yeah.
Okay. So, I just want to make it clear. So the rifle is, and I'm in blue, somewhere behind one of these 5 cushions. Lisa is standing up, not kneel down. You don't know where the Windex and the rag came from, correct? And you are just happen to be standing right here in front of Lisa, and I'll put a C for you. And then Ashlee's kind of standing where her foot is in this picture. Would that be accurate?
Excuse me. That's where she fell.
Okay. And then you don't know why Ashlee's pointing a gun at you, correct?
Not 100%, no ma'am.
Okay, so this just randomly happens then, correct?
If that's what you want to say, yes ma'am.
Okay, and so also with her sister, who she appears to treat like her own, kind of like a daughter in a lot of ways, she's gonna also have a gun that's pointed in yours and her sister's direction?
Yes ma'am.
Okay, and so how are you're able to then move out of the way? Because you agree you're 6'1", 200 pounds, correct?
I was 187 when I got locked up.
Okay, well, you weren't exactly locked up on October 31st, were you?
No, it's 2 days afterward.
Okay, but you're approximately 6'1", 200, correct?
Rounded, yes ma'am.
Okay, because that's what you told Detective Minaj, correct?
Somewhere around there.
Okay, so you're not disagreeing that's what was stated, right?
No ma'am.
Okay, and you agree that Lisa Rucker is smaller than you, correct?
At the time,
We can talk about October 31st, yes.
yes ma'am.
Okay, she's shorter than you, correct?
Yes ma'am.
Weighs less than you, correct?
Yes ma'am.
Okay, and we also know that Ashlee's, what, 5'3", approximately 139 pounds, correct?
About 145.
Okay, so you disagree with what the medical examiner stated?
I don't know if she weighed that last.
Okay, but you heard the medical examiner state that she weighed 139 close, correct?
Yes ma'am.
And so don't agree with me just because if you don't remember, just say I don't remember.
Yes ma'am.
Okay. So you agree then you've got a 10-inch height difference, correct?
Yes ma'am.
Okay. Not only a 10-inch height difference, approximately 61-pound difference too, correct?
Yes ma'am.
Okay. So you're sitting in this very small walkway area. You're able to move to the point that it then strikes Lisa, correct? When I say it, meaning the bullet.
I don't understand what you mean.
Okay.
Like I moved out of the way for her to get hit? Is that what you're saying?
No, I'm saying you've already told us you moved out the way, correct?
I was in motion, yes ma'am.
Okay, so where did you move to? Because that's a very small area, you agree, correct?
Yes ma'am, I just told you I was going this way out the front.
Right. So, but how did you move out the way of the bullet based upon where you just showed us the positioning?
Bad aim.
A bad aim, okay. Now, after Lisa is struck, per your testimony by her own sister, then you stated that there was a struggle over the rifle?
I really struggled. I mean, she was kind of in shock at that point. Like, she couldn't believe it.
Because you talked about a spin around, right?
It spun around and grabbed her.
Matter of fact, you even stepped down today to show us about a
Sure.
spin around with the gun, correct?
Yes ma'am.
Okay. So, how did that spin around occur in that small little area there?
It looks small from this angle, but it's not a small area.
Okay.
Pull out your chart.
You just answer my questions.
Yes ma'am.
That's not a big area, is it?
What do you, I don't understand where you're trying to go with that.
I'm asking you, if you're struggling over the gun, how did that occur in this small area?
There's plenty of room for that to occur.
Okay. You agree that there's no furniture disturbed too, correct?
Yes ma'am.
Okay, so there is nothing around that area that shows a struggle over a gun occurred, correct?
Well, I never said it was a struggle.
You never said it was a struggle?
No ma'am.
Okay, but didn't you say that you all were struggling over the gun?
She didn't want to let it go. We wasn't like tussling, fighting each other over the gun. She just, she held the gun and then when I twisted it out of her hand.
But your finger never touched the trigger, and that's what you told us, right?
Yes ma'am.
So she shot herself with that rifle in the back of her head, correct?
Not intentionally, no ma'am.
She shot herself then in the back of the head with a rifle, correct?
Yes, ma'am.
Okay. And how did that happen? How did she shoot herself in the back of the head with a rifle?
Only thing I can think is when I yanked the gun from her and she was behind, like yanking it away.
Okay, because you heard,
The heck,
I'm sorry, go ahead, I didn't mean to cut you off.
I was just explaining how her hand went, and when you yanked the gun, I mean, it just went off. It wasn't like, do I think she intentionally shot herself? No, of course not.
And that's not what I'm asking. But you're still stating she shot herself, correct?
I didn't touch the trigger, yes, ma'am.
So that's a yes, right? Okay. And you agree she was shot in the back of the head, correct?
That's what they say. You're examining.
No, because they were stating she was shot in the back of the head, correct?
That's what he said, yes, ma'am.
Okay. Are you disagreeing with that?
He knows best, right?
I asked you a question. Are you
No, ma'am.
disagreeing?
No, ma'am.
Okay. So you agree then that she was shot in the back of the head?
Yes, ma'am.
Okay. And so again, if you go and grab her the gun, how is she able to shoot herself in the back of the head with a rifle? How?
Demonstrate it. You see how long your arm is? How long was her arm?
Her lung was very similar to mine.
It's interesting. Maybe you should grab it and show the jurors.
And you don't get to ask the questions. Now, you heard Dr. Gillespie state that in his expert opinion, that the end of the barrel had to be at least 3 feet. Did you hear that?
I think so, yes, ma'am.
Do you agree with that?
Yes, ma'am.
Okay, so let's think about 3 feet. That's something to show you. So we got a yardstick. Now you agree that a yardstick is 3 feet, correct?
You get pretty much, yes, ma'am.
Okay, so let's just say this would have to be the end, okay? Where it touches Ashlee's head, correct? And then this is 3 feet. And that means that at the end of the 3 feet is where the barrel is. Correct?
I don't know how long it is from there.
Okay.
From the handle to the rear, I don't know.
Okay. And so then we talked about just my arm, right? Okay. So back of the head to the end of the barrel, you agree that my finger only goes to the end to where the barrel would be, correct?
Yeah, yes, ma'am.
And it would be even harder if it's in the back of my head, correct? For me to reach. Do you agree? That I can't even reach it? Can we do it for you again?
Yes, ma'am.
Okay. So if I got it back in my head, and I'm reaching, I can't even reach, can I?
No.
So how in the world would Ashlee pull the trigger and shoot herself in the back of the head?
I have no idea to tell you that.
Because it didn't happen that way, did it?
Yes, ma'am, I did.
Even though physically it's not possible.
That's physically possible. You're using a yardstick. Grab the gun and do it.
Well, the thing is, I wouldn't even be able to grab the gun.
And that's not true.
Because this is the 3 feet. So just thinking about it for a moment, okay? I'll make sure I just keep this pointed down.
Yes, ma'am.
So you agree that I would then have to have, because obviously the end of the barrel would have to be pointed at my head, correct? Apologize. But this would have to be pointed back of my head, correct? End of the barrel, right?
If you got your hand around this way of the stock, it will.
I'm not talking about how I'm holding it currently. I'm just, because obviously I want to keep things very safe right now, even though we know it's safe, but still. The end of the barrel, okay? Remember, it would have to be at the end of these 3 inches, okay? Right? And then the other end of the yardstick would be Ashlee's head, correct?
Definitely not.
Okay. Mr. Jackson, can you stand just for a moment? hand reach the trigger. And Mr. Atkinson's arm's longer, we can agree, can't we?
Yes, ma'am.
So you agree then it's physically impossible for Ashlee to have shot herself in the back of the head.
Yes, ma'am.
Okay.
At the angle you're holding that, yes, ma'am.
You stated that you cared and loved Joseph, correct? Like your own son, correct?
Yes, ma'am.
However, you left his mother for dead, didn't you?
Yes, ma'am.
And you left Lisa for dead, didn't you?
Yes, ma'am.
You thought Lisa was dead too, didn't you?
Yes, ma'am.
In fact, you thought you were going to leave no witnesses, didn't you?
What?
You thought you were going to leave no witnesses, didn't you?
I don't understand what you're trying to say.
Okay. You agree that there's only 3 people in the condominium at the time of the shootings, correct?
Yes, ma'am.
Okay. And you thought they were both dead, didn't you? And you fled out that condo on October 31st, didn't you?
Yes, ma'am.
Therefore, leaving no witnesses to what you did, correct?
I ain't did nothing.
Okay. And then you fled, correct?
Left, yes, ma'am.
And you took the murder weapon, didn't you?
Yes, ma'am.
Okay. And you never called police, did you?
No, ma'am.
In fact, you never even called for rescue, did you?
No, ma'am, I did not.
Because you agreed, you could have called for rescue at least.
Yes,
Right?
ma'am.
Okay. And you actually slept in the woods, didn't you?
Yes, ma'am.
And it was cold that night, wasn't it?
Yes, ma'am.
And that's because you were hiding from the police, weren't you?
At that time, yes, ma'am.
Okay. And because you knew they'd be looking for you, didn't you?
Of course.
Okay. Because you knew that your identification would be known, correct?
Yes, ma'am.
Okay. And you got some toothpaste and a toothbrush, correct?
Yes, ma'am.
Because that was what was found in your jacket pocket. You agree that that was your jacket?
Yes, ma'am.
Okay. And you agree that that's the jacket that you used to zip up and cover the rifle, correct?
Yes, ma'am.
Okay. And you went ultimately then to Mr. King's residence, didn't you?
Yes, ma'am.
And you also took out the battery of your cell phone, didn't you?
Yes, ma'am.
Because you did not want the police to track you, did you?
Yes, ma'am.
Okay. And Mr. King tried to get you to turn yourself in, didn't he?
I was coming out to turn myself in anyways.
He had a call,
He talked to me, yes, ma'am.
and he tried to get you to turn yourself in, correct?
I turned myself in that same day.
I'm talking about before the SWAT team came to Mr. King's residence.
Yes, ma'am.
Okay? Because Mr. King left the residence, didn't he, to call the police?
Yes, ma'am.
Okay. And you agree that the robot that Detective Hinton had saw you pacing, holding your rifle, the murder weapon, correct?
At a door frame, yes, ma'am.
Okay. And ultimately then, that's when you surrendered, didn't you?
Yes, ma'am.
Okay. So you agree that this is not an identification case, correct? I mean, your ID's no.
Yes, ma'am.
Okay. And you agree this is not a self-defense case, correct?
No, ma'am.
Okay.
Yeah, I don't understand. Can you I don't know what you mean by that.
No problem at all. You agree that this is not a self-defense case?
No, I don't know.
Objection, Your Honor, he's asking for a legal conclusion that he's unable to give.
All right, if you will phrase your question.
Yes, ma'am.
Yes.
So you agree the only person that had the firearm was Ashlee, correct?
You going back to the scene?
I have to go back a little bit just to rephrase some of my wording.
Yes, ma'am. Yes.
Okay, and I apologize for that, but that's what I need to do, okay? So I just want to make it very clear. The only person that had a weapon that was of deadly force is Ashlee, correct?
At the time of the shooting, yes, ma'am.
No one else had any other weapons, correct? Per your testimony.
When the shooting took place?
Yes. I'm only talking right now about the shooting. Yes.
Yes, ma'am.
Okay. And you agree, based upon your testimony, is that Ashlee shot her own sister, correct?
Yes, ma'am.
Okay. And then also per your testimony, you agree that Ashlee shot herself, correct?
Neither one was intentional.
Right, I'm just saying, for your testimony though, she shot herself, correct?
Yes, ma'am.
Okay. Just have one moment, Your Honor.
Yes.
And when you were coming down the stairs, did you ever see Lyle Scheidemann when you were fleeing the residence?
No, ma'am.
And you agree that these shots happened pretty quickly, correct? One after another?
Yeah.
Okay, and you agree there was only 2 shots, correct?
Yes, ma'am.
And the only 2 people that ended up shot are Lisa and Ashlee, correct?
Yes, ma'am.
No further questions, Your Honor.
All right, thank you. Is there any redirect?
Yes, Your Honor, thank you.
You loved Ashlee, didn't you?
Yes, ma'am, I did.
You love Joseph, didn't you?
Yes, ma'am.
You hate that any of this happened, don't you?
Of course, regardless of all of it, if it could all be redone, I would take the bullet.
Are you proud of your decisions that night? To leave?
By leaving them? No, ma'am, I'm not.
You said that Ashlee likes to do a lot of home improvement projects, right?
Yes, ma'am.
Were some of those underway in the condo at that time?
Yes, ma'am.
And there was blood everywhere, right? You saw some pictures. It seems everybody was bleeding. And so there's blood down outside, inside, all over.
Yes, ma'am.
And you were circling around the apartment, gathering your things, right?
Yes, ma'am.
That include your toothbrush and toothpaste.
I don't honestly remember how they got in my pocket.
But you were getting ready to leave.
Yes, ma'am. Yes, ma'am.
So, and you said Ashlee and Lisa both asked you to leave, right?
I don't recall.
Or
Actually,
either one, I'm sorry, Lisa had asked you to leave. Was that your testimony earlier?
yeah. Yes, ma'am.
But you hadn't left yet, right?
Ma'am.
Because you were gathering your things. Did they seem upset about that?
That's normal stuff. That was normal kind of stuff.
What was normal?
Just,
Well, were they upset that you weren't leaving the house yet?
no, ma'am.
And you knew you couldn't have that gun, right?
Yes, ma'am.
Was that part of the reason you ran?
Yes, ma'am.
Because you need to be arrested if the police got to you just for that?
And I'm a convicted felon.
Now, if Your Honor would allow, I'd like to use the yardstick if the state will allow me.
I'm sorry, I didn't hear you.
I said I'd like to use the yardstick if the state will allow me. I want you to show me where your hands were as relation to hers. Is that
Yes.
permission, Your Honor?
That's fine.
Okay, if I get up now? Or
Yes, you
Yeah,
can,
just right next to
there.
it.
Just again, speak loudly,
just,
because you're not gonna be mic'd up, so that the jurors and the court reporter and I, and everyone can hear you.
Okay, Mr. Absher, what I need you to do is position me how you remember Ashlee being and treat this as the yardstick. Now or as the yardstick. Treat this as the gun, and we understand the gun's a little shorter than this, but we're gonna do our best. Tell me what to do.
I'm sorry, I can't hear you.
That
You
was the second.
can't honestly do it this way with this stick, but then she's got it this way.
Okay, so something like this, and we know it's shorter, but, okay.
Up underneath, right.
Then what happened?
That's when you grab the gun this way.
Okay. And did she look away at any point that you can remember? And how fast did the gun go off from that point that you spun it around?
When I did it this way, this hand's gone.
Right.
This comes off, you go this way,
That's right.
this yank's going right
Got
there.
it. Thank you, Mr. Absher.
This one.
So even with the yardstick longer than the rifle, it's possible that she could have been shot where she was.
yes, ma'am.
And you did hear Mr. Gillett, or my apologies, Dr. Gillespie say that his opinion was that the shot was 3 feet away. But you also remember him saying that any evidence of the distance could have been washed away by the blood. Do you recall hearing that testimony?
Yes, ma'am.
And again, you said Ashlee liked to do a lot of home improvement projects. You don't happen to know how big the tiles in the apartment were, do you?
Them looks like probably, what, foot and a half?
Okay. But you don't know, you didn't know.
I'm just going off the picture, yes, ma'am.
And so when you left the apartment, did you believe you had committed a crime?
I haven't a gun?
Any crime,
No, ma'am.
other than having the gun?
Yes, ma'am.
And you were afraid you'd get arrested, right? And have to go on trial, correct?
Yes, ma'am.
I have no more questions.
All right. All right, I think now then is a good time to take a recess from the jury, but let me just inquire of the attorneys for scheduling purposes. Are there any other witnesses the defense wishes to present?
No, Your Honor, at this time, defense rests.
All right, so the defense has now rested its case. Does the state anticipate any type of rebuttal case?
Yeah, I would just need 1 moment, probably like 5 minutes.
Okay, let me then just ask the jurors to leave their notepads on their seats and just have a step into the juror room. I'm just deciding whether to send you all for an early lunch or to continue on here for another normal lunch break. So if you'll just step inside with a reminder that you're not to talk about. All right, jury's out of the courtroom. Mr. Absher, you may resume your seat by your attorneys.
All right, yes, ma'am.
Okay,
So take this coat with me?
sure?
Your man, just step out for 1 quick minute.
Yes.
Thank you.
blood where Ashlee was shot. The story makes no sense because it isn't true. He had 40 hours hiding in the woods and at his friend's house to try to come up with an explanation that makes sense, and he couldn't do it. He had 5 years to come up with an explanation for how this makes sense, and he couldn't do it. And the reason for it is because the only explanation is that he is responsible for their murders, and he just can't tell you that. So ultimately, at the end of this, we just ask you to rely upon your common sense. This defendant used violence against Ashlee Rucker. Joseph Granazio tried to help his mother. Lyle Scheidemann tried to defend the women in the house. This defendant got angry and armed himself with a rifle. He shot Lisa Rucker in the face. Ashlee Rucker tried to run to her sister. He shot her in the back of the head from a distance greater than 3 feet. He then left the women, left the children, took the gun, and hid. What he said today on that witness stand is an offense to the evidence, it's an offense to the truth, it's an offense to the natural laws that govern the earth. He attempted to murder Lisa Rucker with premeditation. He did murder Ashlee Rucker with premeditation. Find him guilty.
All right, thank you, Mr. Atkinson. Defense closed.
Good afternoon. This whole case has been a horrific. It's not just Lisa Rucker or their children or anybody else who's been living a nightmare. It's also been Chad Absher. Because he's been waiting for 5 years to get to trial over something he didn't do. I'm not going to pick and choose the evidence just to tell you how to think like the state did, because I know you are all smart enough to know that you heard Lisa say they weren't touching each other when I got in there, or she conveniently couldn't remember her crimes of dishonesty when I got there, but she had a sparkling memory for 5 years ago. She told you she wasn't drinking, but her DNA shows up on a bottle. And not only that, she demonstrates that she steals habitually and didn't spend a day in jail while this case was pending anyway. She has a civil suit pending. She stands to get a lot of money out of this, and she needs Mr. Absher convicted in order to get that. And who would want to blame their sister? If this really happened, that's my sister. I would be hard pressed to say
to invoking the golden rule.
Okay, overruled. Go ahead.
I think most people would be hard pressed to want to blame your sister for something like this. This is horrible what happened. There are no winners here. But it seems that Lisa Rucker got Lyle to come along with her on this story, so what she did for 10 days. And we want to put Chad in jail because everybody wins then, right? It's Chad's the bad guy. It's up to you all to determine. The state showed you, you'll get the rules, all the elements. Take each and every single witness, go through each of them. Did they have an opportunity? Do they have benefits? Compare them all. Because you know what? The only eyewitness of what happened that doesn't have a conviction for a crime of dishonesty is Mr. Absher. He's demonstrated no ability to lie, honestly, because he sat here for 5 or how many days we've been sitting here, 3 days, listening to all this testimony and didn't get up on the stand and testified consistent with that. He testified to what he remembered and how he remembered it. He loved Ashlee. He hates that this happens. No one wanted this to happen. But the state wants you to believe that he just out of nowhere, after a fight about keys, got some gun out and started shooting up the place. It's just not what happened, and it doesn't make sense. And you have to use your reasonable common sense to evaluate what each and every witness told you. There are 3 witnesses to the shootings, right? Unfortunately, Ashlee has passed, so she can't tell us what happened. So now we have Lisa and Chad. You heard both of their stories. You heard them both tell you what happened. They're different in spots. For reasons I can't imagine, but they are different in spots. But this is how they remember it. Because you know what? Everybody who was drinking that night had something to drink at least. Even though Miss Rucker wouldn't admit that. She can't even admit about her lies. So I don't know how you would expect to believe her story leading up to this, especially when she stood up there and said with such conviction, Chad shot my sister. She wants it to be him. She needs it to be him. But it's not. And this whole situation is awful. And it's tragic all around, mostly for the children, that Chad loved like his own. Spent 4 years with those kids, taking them places, watching TV with them, letting them ride his lawnmower. Ashlee was mad at him about the keys still. You keep hearing an argument. She was mad. There was an argument going on. She was the one that was mad. He wouldn't give the keys back, wouldn't give the keys back. Then you heard Lisa say, well, she just walked up right behind him and got the keys out of his pocket. She was mad still. She's still really mad. So, Chad, after drinking, he told you. See, and that's the thing. Chad told you the things that weren't so nice either. He'll tell you and admit to you, like, look, I'm not proud of what I did. I was a coward for that. I was scared and I ran. He told you that he thought that they were both dead. He didn't think they needed help at that point. He was scared. He was already collecting his stuff. The state wants you to believe that he was collecting his stuff to go hide out. The thing is, they've told you, and the witnesses have told you, they've repeatedly told him to leave. What do you think he was trying to do? He's been there almost every single day. He's got lots of stuff over there. He went to sleep. He woke up being beaten on. He's 6'1". They keep talking about how big he is, right? You saw how little Lyle was when he came in here. That man jumped on an intoxicated man at Lisa's direction. Why? But that's what happened. And he woke up, he got his tooth knocked out, he's bleeding everywhere, there's blood all over that apartment. We don't even know whose blood is who in some places. So the fact that there's blood in this spot, but not in the other part of the picture that the state didn't show you, potentially, that's up to you. You look at all of this and you see whether all the physical evidence. They say you can see into the apartment, you can see in the top. He claimed he was able to see a body on the floor. It's not possible. It's not possible to see under the couch and in there to see what's going on. He said he was able to see her laying. It's not possible. You have to use your common sense to evaluate the weight of each evidence. How credible are these people? Does the story make sense? It's a crazy story, and there are spots that your questions are not going to be answered like the state keeps telling you. But if there's a reasonable alternative explanation, if there's a reasonable doubt, your verdict has to be not guilty. State keeps wanting you to believe that the gun had to be 3 feet away. You're even getting up here and pointing it at themselves to show you that. You'll have it back there. You see the trigger's about halfway up. It's not 3 feet from here, the trigger. He explained to you how her finger was already in the trigger and he grabbed it and twisted it. She didn't have to find her way into that trigger. And the reason he grabbed it is because she just shot at him. It was split seconds. Yes, he's pacing around. Lisa told you he's pacing around. I don't know what he was doing. No, he was pacing around getting his stuff. He's trying to get out of there. Because Lyle had run out, had beat on him, run out of the house. Now they're all telling him to leave. He's like, all right, let me get my stuff. He walks out, and barely misses being shot. Grabbed the gun, and the woman he loved, to the point where he had tears in his eyes about it, is now dead. He didn't want that. He didn't do it, he didn't want it. So he ran. And the state wants you to believe the only reason you would ever run is because you committed a crime. Someone just shot at Mr. Absher. He tried to get the gun from her, and that person ended up dead too. He's drunk. He had some pills. He continued to get his crap and leave. Excuse my language. Continued to get his stuff and leave. He was scared. He knew Lisa wouldn't say it was, what really happened. He was in a hurry to get arrested. There could be other reasons for that. He was afraid he'd be arrested and have to sit and wait to be brought to trial for a murder he didn't commit. That's why he ran. He also admitted to you that he has a felony and he shouldn't have had the gun. So he at least knew that when he ran. Maybe it wasn't that he killed them in cold blood. Maybe the whole situation got out of hand and he got scared. Now getting into some of the physical evidence, again, medical examiner, when I had asked him, is it possible, and you saw the pictures, there was a lot of blood. She was also placed on a sheet when she went in, as the doctor told you, to the medical examiner's office. Her head was not covered, and you can see in the pictures that the blood is getting on the sheet. And then he had to shave her head to get to it. And he said it's possible that, yes, the sentence definitely could have been washed away. It's up to you to determine whether that's reasonable or not. I submit to you it is. Once you look at the pictures, I think you would be able to arrive at the same thing. The DNA evidence, all of it, lines up with Chad's story. You can see, the state, again, wants you to believe that it's not possible. You're gonna have to look at it yourself, because Chad got up there and told you the truth as he remembered it. And like I said, you didn't hear him tailor his story to what he heard all week. He could have said, yep, she got shot, yep, and this is how it happened. Nope, he didn't. He's telling you exactly, because it's how he is. What the evidence did show you is that some people are lying about something. It's just up to you to determine how important that is to the overall credibility of that witness. I submit to you, Chad didn't tell you a single lie. He told you exactly how he believes it happened. And he's not proud of his decisions. He's not proud of what happened. He's not proud that he's in this situation. And he's, quite frankly, devastated that he did lose the woman he loved. He no longer sees Joseph. He no longer sees Colton. He no longer got to see anybody. I mean, he didn't do this. You have to look at the evidence, and you are the fact finders. You are the ones that determine who's credible, who's not, and as the state told you, you can take all, some, or none of it from any witness, from any piece of evidence. Just ask yourself what makes sense. Line them up, put it together. What makes more sense? Again, there's an alternate reasonable explanation, or you are vacillating between an abiding conviction of guilt. You can't quite stay there. The only answer would be not guilty. really encourage you to take the time to really, really evaluate each witness, each piece of evidence, line it all up with Chad's story. Because it makes sense. It certainly makes more sense than him randomly shooting somebody for no apparent reason. If I may have just one moment, Your Honor.
Yes.
The state also said Joseph should have lied better. I don't know what that means. I would hope everybody came in here telling the truth. But it's clear people didn't, because everything doesn't make sense. The truth is the truth, and he told you what his truth is. Like I said, pay attention to what's not there. If you have questions that aren't answered that are affecting your ability to have an abiding conviction of guilt, you have to say not guilty. We have to have all of that. Look at whether is there evidence missing that you need, things of those natures to get to that beyond a reasonable doubt. You have to do not guilty if you can't be there. And we trust and believe that you or jury can take that opportunity, and please, please take the time to evaluate each and every piece of evidence, because you are the fact finders that determine the credibility. Mr. Absher, his family, and everybody in this courtroom appreciates your time. Thank you.
Thank you very much, Ms. Flores.
Thank you.
All right, state rebuttal, please.
One thing that the defense and I agree about is that people definitely did not tell the truth. However, we disagree on who sat on that witness stand and didn't tell the truth. And that's the defendant, because again, it goes back to that line that he cannot cross. Admit what you can't deny, deny what you can't admit. Because he is the only witness in this entire case who got to listen and see all the evidence. And the defense said he listened to all the evidence and it was inconsistent. Oh, why? Goes back to common sense, because if he's consistent with Lyle, Lisa, Joseph, and the physical evidence, then he's guilty. It goes back to that line. He can't get up there and say the same things. Then he's admitting to first-degree murder. He's then admitting to attempted first-degree murder, so he can't. Of course he's getting up there as inconsistent. So now we are supposed to believe the drunk, on pills, convicted felon, armed and dangerous with this rifle. That is who we're supposed to believe. But forget about the physical evidence. That's not consistent with what he says. But let's wait. Let's pause for a second. What did our DNA expert, Ms. Carter, tell us? What did the defendant tell us? He admitted to walking out with this gun. He admitted that it was his. What is 96% DNA on this gun? The defendant's. His DNA on this gun, and then the DNA of Lisa and Ashlee on these bullets. That's what our evidence tells us. The defendant intended targets to have no witnesses. As he told you on that stand, he thought he left them both for dead, no one to testify against him. That's what our DNA tells us. Gun, DNA, murder weapon, bullets, one with Lisa's name on it, one with Ashlee's name on it. That's what our DNA tells us. Let's not believe Lisa. She steals. Yep, she steals. Guess what? Got to be accountable for them. But we're here to talk about murder. And also what was important, the reason why the dates were said about Detective Anash that he met with Lisa Rucker, they were given before. October 31st, later in the day, November 2nd, November 21st. Also, too, the map. Lisa Rucker wasn't told the physical evidence. Schottenman wasn't told the physical evidence. Joseph Graziano wasn't told the physical evidence. But what is the map that Lisa Rucker drew? It's consistent with the physical evidence. They've always stated 2 gunshots, we got 2 casings. 2 people shot, we got 2 bullets. We've got blood spots. Lisa Rucker didn't know where the blood was. Well, Schottenman, did he come in and know at that point where the victims were? He did. He didn't know about bullets, where they're located. He didn't know about it. These are people talking about their memories and what they know. But what does the defendant know? He gets to see all of this. They did not have that advantage. That's because they didn't need it. Because it goes back to the truth's the truth. And it just doesn't make sense that Lyle would just go in out of the blue, where the defendant even admitted there was no beef. He's just going to go and beat him up for no reason while they've all retired to their bedrooms for the night to go to bed. Doesn't make sense. And one thing we can also agree about, the defendant is a coward. But what makes him a coward is he shot 2 unarmed women. That's what makes him a coward. Not only did he do that, he left 2 children to defend for themselves. That's a coward. Another thing too, again, you rely on your own testimony, but when Lyle testified and he stated that he could see inside of that condominium, he verified to Mr. Atkinson, I can see from the waist up. I couldn't see past the couch. So he didn't say I could see a dead body or a body on the ground when he's standing outside. He said I could see her from the waist up. And then he said she was out of my view. He saw the bodies when he went back into the condominium. Again, rely on your own memory, though. That we submit to you, that's what Lyle Schottenman stated on the record. Another thing, too, the defendant is so devastated. He's so devastated that he only thought about himself. That's what the defendant is devastated about. Himself. Getting caught. Having a witness live to tell what happened. That's why the defendant is devastated. You know, it's interesting, the defendant stated on the stand during cross-examination, well, Miss French, you've waited 5 years to cross-examine me. No, ladies and gentlemen. We've waited 5 years for justice. So, ladies and gentlemen, as you heard from Mr. Atkinson, we have proven this case beyond a reasonable doubt. I don't need to go back through all of that. The witness testimony, we talked about different kinds of evidence during jury selection, testimonial evidence, physical evidence. And we submit to you that it agrees. And again, too, we would expect there to be some inconsistencies. We would expect some memories to fade, because it has been 5 years. But, again, it goes back to that simplification of that mayonnaise, that mustard, whatnot, and the elements we have to prove. So it comes down to, ladies and gentlemen, here we are, basically the 5-year anniversary of that horror story that Lisa Rucker can't turn off in her head, that Joseph Graziano cannot turn off in his head. The Rucker family, Lisa and Joseph cannot turn off, Colton cannot turn off. Because on that date, October 30th, 2017, going into October 31st, 2017, Christina Ashlee Rucker woke up like normal. She lived her life like normal. So did Lisa Rucker, so did Joseph Graziano, and so did Colton Barron. Christina Ashlee Rucker did not know that her life was about to end, that her time on this earth was just about to go on. Lisa Rucker did not know she was about to be shot, potentially lose her life, or lose her sister. Forever, Christina Ashlee Rucker will be 30 years old, 5 days shy of her 31st birthday. Joseph Graziano will be forever 9 years old when he lost his mom. So, ladies and gentlemen of the jury, you all will not change what happened on October 31st, 2017. However, you all will forever define what happens. So just like during jury selection, when I asked you all, do you all agree to hold people accountable for his or her actions? You all agree. So what the state of Florida is asking you now, that presumption of innocence, that cloak of innocence is gone. That evidence has shown beyond a reasonable doubt that the defendant is guilty of first-degree murder, that he is guilty of first-degree attempted murder on Lisa Rucker, and find the defendant 5 years almost to the day guilty. Thank you all.
All right, thank you. All right, ladies and gentlemen, it's been an hour and a half total. I'm going to give you a recess before I read you the instructions, because the instructions will take about 20 to 30 minutes, and I don't want interruption during that time. So if you'll leave your notepads behind, you can step into the jury room to use the facilities, but please do not talk about this.
Especially that guy with the glasses on.
I even started.
All right, then. We'll give folks a couple more minutes to come in, but once I begin, I want the doors locked. Thank you. Please lock the outer doors. I am not going to allow anyone else to come in while I'm reading jury instructions. Okay, and for those that have come in, you of course are welcome to come in. I need everybody's cell phones turned off. I don't want any distractions or interruptions. You will not be able to leave during my reading of the jury instructions that I anticipate will take anywhere from 20 to 30 minutes. So if you think you need to use the restroom, then you may need to leave right now. But we cannot interrupt the reading with any kind of noise or distraction, or interruption rather, so that the jury has a full understanding of the law that they are to apply. All right, with that, then, any reason we can't bring the jury out to instruct them on the law?
No, Your Honor.
Okay, let's bring out the jury, please.
Jurors entering the courtroom.
Thank you, ladies and gentlemen. You may take your seats. All right, members of the jury, you have now heard and seen all the evidence introduced in this case. You have now listened carefully to the arguments of the attorneys, and now I direct your attention to the second part of the instructions, which I am required to give you and which I remind you, you are required to follow. For your convenience, the jury instructions are going to appear on the monitors in front of you so that you can easily follow along as I read them to you. In addition, I will send in one hard copy of the instructions for your use during your jury deliberations. So if you'll now turn your attention to the monitors. All right. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Chad Absher, the defendant in this case, has been accused of the crimes of murder in the first degree and attempted murder in the first degree. Chad Absher is accused of first-degree murder in count 1. First-degree murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Christina Ashlee Rucker was killed by Chad Absher, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder or second-degree murder or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. Number 1, when the killing is committed by accident and misfortune and doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or, number 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any weapon that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Chad Absher may be found guilty of of first-degree murder or any lesser included crime. As to count 1, to prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Christina Ashlee Rucker is dead. Number 2, the death was caused by the criminal act of Chad Absher. Number 3, there was a premeditated killing of Christina Ashlee Rucker. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If you find that Chad Absher committed first-degree premeditated murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm and in doing so caused great bodily harm to or the death of Christina Ashlee Rucker, you should find the defendant guilty of first-degree premeditated murder with discharge of a firearm causing great bodily harm or death. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that Chad Absher committed first-degree premeditated murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of first-degree premeditated murder with discharge of a firearm. If you find that Chad Absher committed first-degree premeditated murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of first-degree premeditated murder with actual possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. To actually possess a firearm means that the defendant, A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. As to count 1, to prove the crime of first-degree felony murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Christina Ashlee Rucker is dead. Number 2, while engaged in the commission of an attempted first-degree premeditated murder, Chad Absher caused the death of Christina Ashlee Rucker. Or, while escaping from the immediate scene after committing or attempting to commit an attempted first-degree premeditated murder, Chad Absher caused the death of Christina Ashlee Rucker. Number 3, Chad Absher was the person who actually killed Christina Ashlee Rucker. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. Attempted first-degree premeditated murder will be defined later in these instructions. Now, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proven beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of murder in the first degree are murder in the second degree and manslaughter. As to count 1, to prove the lesser included crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Christina Ashlee Rucker is dead. Number 2, the death was caused by the criminal act of Chad Absher. And number 3, there was an unlawful killing of Christina Ashlee Rucker by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, number 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and, number 2, is done from ill will, hatred, spite, or an evil intent, and, number 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. If you find that Chad Absher committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, he discharged a firearm, and in doing so caused great bodily harm to or the death of Christina Ashlee Rucker, you should find the defendant guilty of second-degree murder with discharge of a firearm causing great bodily harm or death. And great bodily harm has previously been defined. If you find that Chad Absher committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of second-degree murder with discharge of a firearm. If you find that Chad Absher committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of second-degree murder with actual possession of a firearm. Firearm has been previously defined, and to actually possess a firearm has been previously defined. As to count 1, to prove the lesser included crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Christina Ashlee Rucker is dead. And number 2, Chad Absher intentionally committed an act or acts that caused the death of Christina Ashlee Rucker. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I've previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death. Only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Chad Absher committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of manslaughter with a firearm. Firearm has been previously defined already. If you find that Chad Absher committed manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty only of manslaughter. Chad Absher is accused of attempted first-degree murder in count 2. Attempted first-degree murder includes the lesser crimes of attempted second-degree and attempted manslaughter by act, all of which are forms of attempted homicide and aggravated battery, all of which are unlawful. However, an attempted homicide that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find that there was an attempted homicide of Lisa Danielle Rucker by Chad Absher, you will then consider the circumstances surrounding the attempted homicide in deciding whether it was attempted first-degree murder, or attempted second-degree murder, or attempted manslaughter by act, or aggravated battery, or whether the attempted homicide was excusable or resulted from the justifiable use of deadly force. An attempted homicide is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the attempted homicide. An attempted homicide is excusable and therefore lawful under any one of the 3 following circumstances. Number 1, when the attempted homicide is committed by accident and misfortune, and doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or number 2, when the attempted homicide occurs by accident and misfortune in the heat of passion, upon any sudden and sufficient provocation, or number 3, when the attempted homicide is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used, and the attempted killing is not done in a cruel and unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm, if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. And again, great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Chad Absher may be found guilty of attempted first-degree murder, or attempted second-degree murder, or attempted manslaughter by act, or aggravated battery. I'm going to eliminate some words in this instruction. All right. As to count 2, to prove the crime of attempted first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Chad Absher did some act intended to cause the death of Lisa Danielle Rucker that went just beyond thinking about it. Number 2, Chad Absher acted with a premeditated design to kill Lisa Danielle Rucker. And number 3, the act would have resulted in the death of Lisa Danielle Rucker, except that someone prevented Chad Absher from killing Lisa Danielle Rucker, or he failed to do so. A premeditated design to kill means that there was a subconscious decision to kill. The decision must be present in the mind at the time the act was committed. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the act. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the act was committed. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the attempted killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the attempted killing. If you find that Chad Absher committed attempted first-degree premeditated murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm and in doing so caused great bodily harm to or the death of any person, you should find the defendant guilty of attempted first-degree premeditated murder with discharge of a firearm causing great bodily harm or death. Great bodily harm has previously been defined. If you find that Chad Absher committed attempted first-degree premeditated murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of attempted first-degree premeditated murder with discharge of a firearm. If you find that Chad Absher committed attempted first-degree premeditated murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of attempted first-degree premeditated murder with actual possession of a firearm. Firearm has been previously defined, and to actually possess a firearm has been previously defined. Now, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proven beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of attempted first-degree murder are attempted second-degree murder, attempted manslaughter, and aggravated battery. As to count 2, to prove the lesser included crime of attempted second-degree murder, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Chad Absher intentionally committed an act which would have resulted in the death of Lisa Danielle Rucker, except that someone prevented Chad Absher from killing Lisa Danielle Rucker, or he failed to do so. And number 2, the act was imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, number one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. And number two, is done from ill will, hatred, spite, or an evil intent. And number three, is of such a nature that the act itself indicates an indifference to human life. In order to convict the defendant of attempted second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. If you find that Chad Absher committed attempted second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm and in doing so caused great bodily harm to or the death of any person, you should find the defendant guilty of attempted second-degree murder with discharge of a firearm causing great bodily harm or death. And great bodily harm has been previously defined. If you find that Chad Absher committed attempted second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of attempted second-degree murder with discharge of a firearm. If you find that Chad Absher committed attempted second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of attempted second-degree murder with actual possession of a firearm. Firearm has been previously defined, and to actually possess a firearm has been previously defined. As to count two, to prove the lesser included crime of attempted manslaughter, the state must prove the following element beyond a reasonable doubt. Chad Absher intentionally committed an act which would have resulted in the death of Lisa Danielle Rucker, except that someone prevented Chad Absher from killing Lisa Danielle Rucker, or he failed to do so. However, the defendant cannot be guilty of attempted manslaughter by committing a merely negligent act. Every person has a duty to act reasonably and use ordinary care toward others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. In order to convict of attempted manslaughter, it is not necessary for the state to prove that the defendant had an intent to cause death. Only an intent to commit an act which would have caused death and was not justifiable or excusable attempted homicide, as I've previously instructed you. If you find that Chad Absher committed attempted manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of attempted manslaughter with a firearm. And again, firearm has previously been defined. If you find that Chad Absher committed attempted manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty only of attempted manslaughter. As to count two, to prove the lesser included crime of aggravated battery, the state must prove the following two elements beyond a reasonable doubt. The first element is a definition of battery. Number one, Chad Absher actually and intentionally touched or struck Lisa Danielle Rucker against her will. Number two, Chad Absher, in committing the battery, used a deadly weapon. Or, Chad Absher intentionally or knowingly caused great bodily harm. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it was used or threatened to be used in a manner likely to cause death or great bodily harm. Great bodily harm has intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. A battery may be found as a result of the intentional touching or intentional striking of something other than the actual body of the person. However, that object that is touched or struck must have such an intimate connection with the person that it is to be regarded as part of or as an extension of the person. If you find that Chad Absher committed aggravated battery, and you also find beyond a reasonable doubt that during the commission of the crime, he discharged a firearm and in doing so caused great bodily harm to or the death of any person, you should find the defendant guilty of aggravated battery with discharge of a firearm causing great bodily harm or death. If you find that Chad Absher committed aggravated battery, and you also find beyond a reasonable doubt that during the commission of the crime, he discharged a firearm, you should find the defendant guilty of aggravated battery with discharge of a firearm. If you find that Chad Absher committed aggravated battery, and you also find beyond a reasonable doubt that during the commission of the crime, he actually possessed a firearm, you should find the defendant guilty of aggravated battery with actual possession of a firearm. Firearm has been previously defined, and to actually possess a firearm has been previously defined. The state must prove that the crimes were committed on October 31, 2017. It must be proved only to a reasonable certainty that the alleged crimes were committed in Duval County. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. And some things you should consider are, number one, did the witness seem to have an opportunity to see and know the things about which the witness testified? Number two, did the witness seem to have an accurate memory? Number three, was the witness honest and straightforward in answering the attorney's questions? Number four, did the witness have some interest in how the case should be decided? Number five, does the witness's testimony agree with the other testimony and other evidence in the case? Number six, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Number seven, did the witness at some other time make a statement that is inconsistent with the testimony he gave in court? And number eight, has the witness been convicted of a felony or misdemeanor involving dishonesty or false statement? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You have heard the testimony of a child. No witness is disqualified just because of age. There is no precise age that determines whether a witness may testify. The critical consideration is not the witness's age, but whether the witness understands the difference between what is true and what is not true, and understands the duty to tell the truth. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. You have heard testimony of eyewitness identification. In deciding how much weight to give this testimony, you may consider the various factors mentioned in these instructions concerning credibility of witnesses. In addition to those factors, in evaluating eyewitness identification testimony, you may also consider, number one, the capacity and opportunity of the eyewitness to observe the offender based upon the length of time for observation and the conditions at the time of observation, including lighting and distance. Number two, whether the identification was the product of the eyewitness's own recollection or was the result of influence or suggestiveness. Number three, the circumstances under which the defendant was presented to the eyewitness for identification. Number four, any inconsistent identifications made by the eyewitness. Number five, any instance in which the eyewitness did not make an identification when given the opportunity to do so. Number six, the witness's familiarity with the subject identified. Number seven, lapses of time between the event and the identification. Number eight, whether the eyewitness and the offender are of different races or ethnic groups and whether this may have affected the accuracy of the identification. And number nine, the totality of circumstances surrounding the eyewitness's identification. Now, there are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Number one, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Number two, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. Number three, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Number four, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Number five, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Number six, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Number seven, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Now, you may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. You will turn to those now. All right, ladies and gentlemen, I am holding in my hand two separate verdict forms. The first one reads State of Florida versus Chad Absher, and it says verdict count 1. The first verdict option you have reads, we the jury find the defendant guilty of first-degree murder as charged in the indictment. If that is your unanimous verdict, you would mark that line with an X or a check. You then have to come below that for sub-findings. And if you find the defendant guilty of murder in the first degree, then you must check one or both of these lines depending on what the jury decides. And that is, number 1, we further find the killing was premeditated, and number 2, we further find the killing was done during the commission or attempted commission of a felony, to wit, attempted first-degree premeditated murder. So that is premeditated first-degree murder and felony murder. And then if you find him guilty of the crime as charged of first-degree murder, you also have to make one of the following 4 sub-findings. And here you just check one of the 4 boxes, not all of them. And they read as follows. We find the defendant discharged a firearm causing death or great bodily harm during the commission of the offense, or we find the defendant did actually possess and discharge a firearm during the commission of the offense, or we find the defendant did actually possess a firearm during the commission of the offense, or we find the defendant did not actually possess a firearm during the commission of the offense. Whatever you unanimously find beyond a reasonable doubt, you would mark the appropriate line with an X or a check. The second verdict option as to count 1 is we, the jury, find the defendant guilty of second-degree murder, a lesser included offense. If that is your unanimous verdict, you mark that line with an X or a check. And then again, you have the same 4 sub-findings, of which you would mark 1, depending on what the jury found unanimously beyond a reasonable doubt. So you would mark the appropriate line with an X or a check. The third verdict option you have for count 1 is we, the jury, find the defendant guilty of manslaughter, a lesser included offense. And if that is your unanimous verdict, you'd mark that line with an X or a check. Here, however, there's only 2 sub-findings that the jury would consider, and you would mark one of the 2 depending on the jury's unanimous finding. And that reads as follows. We find the defendant did carry, display, or use a firearm during the commission of the offense, or we find the defendant did not carry, display, or use a firearm during the commission of the offense. So whatever you unanimously decide, you mark the appropriate line with an X or a check. And the last verdict option reads, we, the jury, find the defendant not guilty. If that is your unanimous verdict, you mark that line with an X or a check. So say we all done at Jacksonville, Duval County, Florida, and then there's a line for the foreperson to sign and date the verdict as to count 1. You also have a 2-page document titled Verdict Count 2. And it is styled State of Florida versus Chad Absher. And similarly, you have different verdict options. In this case, there are 5 of them. The first one is, we, the jury, find the defendant guilty of attempted first-degree premeditated murder as charged in the indictment. If that is your unanimous verdict, you mark that line. And then you have to pick one of the following 4 sub-findings regarding the firearm, similarly to what I just read you a moment ago, so I'm not going to read them again. But you would unanimously decide which of those 4 and mark the appropriate line with an X or a check. The second verdict option is we, the jury, find the defendant guilty of attempted second-degree murder, a lesser included offense. And if that is your unanimous verdict, you would mark that line. And then you would select one of the 4 following sub-findings. The third verdict option is we, the jury, find the defendant guilty of attempted manslaughter, a lesser included offense. And if that's your unanimous finding, you mark it. And below it, there are 2 sub-findings, and the jury would need to unanimously agree on one of those and mark the appropriate line. The fourth verdict option reads, we, the jury, find the defendant guilty of aggravated battery, a lesser included offense. And if that's your unanimous verdict, you would mark it. And then you have 2 sub-findings you need to make. The first is, if you find the defendant guilty of aggravated battery, then you must choose one of the following findings. Either that it was aggravated because the defendant used a deadly weapon, or defendant caused great bodily harm. You would mark the appropriate line with an X or a check. And then the sub-findings, the same 4 regarding the firearm. You would select unanimously one of those and mark that line with an X or a check. And the last verdict option reads, we, the jury, find the defendant not guilty. So say we all. Done at Jacksonville, Duval County, Florida. And again, a line for the foreperson to sign and date the verdict as to count 2. All right. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged. Now, in just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is to choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed to the verdict, and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of this case. So if you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have voted, do not disclose the actual vote in the note. If you have questions, I will speak to the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer, and I will answer any questions, if I can, either in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. However, as is my policy, I will send in the rifle, but I am not sending in a magazine or live rounds together. If you wish to review the magazine and the live rounds, I will then retrieve the rifle from the jury room and send those 2 items in. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law, and no juror has the right to violate the rules we all share. So that, ladies and gentlemen, will conclude the jury instructions. As advised, 1 hard copy will be sent to the jury room with you. The 2 verdict forms are prepared to go back with you, as are all of those items in evidence with the exception of the magazine and the live round. And so at this time, I will excuse, that is, you can't appeal the issue of your guilt or innocence. Do you understand that?
I do now.
Okay. Also, if you are not a U.S. citizen, by being convicted of this crime, you will be subject to deportation under our federal immigration laws. Do you understand that?
The immigration's supposed to pick me up.
I'm sorry?
The immigration's supposed to pick me up.
Where are you from?
Yes, ma'am, yes, ma'am.
Okay. Yeah, this is not a joking matter, Mr.
It
Absher.
is.
I mean, this is serious.
It is, I mean,
Okay.
the people out there. Yes, ma'am.
I mean, the jury is doing its job, the attorneys are doing their job, I'm trying to do my job. This is not funny.
Yes, ma'am. Yes, ma'am.
Also, do you understand that by pleading guilty, if in the past you've ever been convicted of any sexually motivated offenses, and I'm not aware that you have, but if you have any of those in your past, by being convicted of an additional crime, even if it's a non-sex offense, do you understand that you could be subject to what's called an involuntary civil commitment as a sexually violent predator under the Jimmy Rice Act? Do you understand that? This would only apply to you if you have prior sex offenses.
No, no, yes, no,
Okay, I just have to advise every defendant of the consequences of pleading guilty.
yes, ma'am.
All right, and state defense, are you aware of any DNA evidence as to this count that would exonerate Mr. Absher?
Not to exonerate, Your Honor.
Okay, and of course, I heard the DNA analyst who testified about the DNA found on the rifle that did match to Mr. Absher. And of course, again, I sat through the trial. I don't need a factual basis recited. I've heard the testimony of Mr. Absher himself, who admitted to possessing the firearm, so I will find there's a factual basis for the entry of this plea of guilty. Is there any exception or objection to a factual basis?
No, Your Honor, stipulate for purposes of.
Okay. Then I will further find that Mr. Absher's plea has been entered freely, willingly, and voluntarily with a full understanding of the nature and consequences of doing so. So, Mr. Absher, I'm going to accept your plea of guilty on count 3, the possession of a firearm by a convicted felon, and we will pass it for sentencing. I won't announce the date yet, so let's just wait and see what the jury does with count 1 and 2, and then we'll put it all together if necessary.
Yes, ma'am.
Do you have any questions of me? Okay, so you understand then that this jury will not be asked to decide a verdict as to count 3.
Correct.
Okay.